And welcome to the 20th meeting of the Net Zero Energy and Transport Committee for 2025. Our first item of business is to agree to take item 4 in private. Item 4 is the consideration of our work programme. Are we agreed? We are agreed. Second item of business is the consideration of a negative SSI, the Road Traffic Permitted Parking Area and Special Parking Area Highland Council Designation Amendment Order 2025. This is laid under the negative procedure, which means that it will come into force unless the Parliament agrees a motion to annul, and there have been no such motion has been lodged. The Delegated Powers and Law Reform Committee have made no comment on the instrument. Does any member want to make any comment on the instrument? Mark.
Yeah, thanks. Just a brief comment, Convener. I'm just quite interested in how in practice this will actually work. So it might be worth us writing to the Highland Council, because I'm aware that we have a number of tourist hotspot areas in Scotland which are on effectively clearways on major A roads, and often you get coach parties, you get a large number of tourists that come to the area. There's often dangerous parking, and often those A roads are actually being blocked. So what I've seen, certainly in my region, is the police have needed to be actively involved in clearing cars away and enforcing things. So I'm just interested to know kind of where that kind of work with the police stops and where the work of the councils kind of start. The other issue is just in relation to hospital parking, which I know is an issue across Scotland, where you have private security firms effectively that are doing the parking enforcement for the local authority, even though in some council areas the council itself has taken on the responsibility through decriminalised parking for doing that enforcement, and there's often a mismatch there. So I think we get these orders coming up to the committee from time to time. They look pretty straightforward. They are pretty straightforward, but there are issues there about who's doing the kind of safety work, the enforcement work, and then the issue of hospital car parking, I think, is a bit of an anomaly which still exists. So it'll be interesting to see what the Highland Council would say in relation to those 2 points.
Okay, does anyone else have any comments? My only comment is I think there's 27 areas listed on this SI where parking would be limited. I come from the Highlands and I struggle to understand where they all are. I think it would have been much easier when these are produced, if a map was produced, so that you didn't have to try and work out from the 27 areas where each of them are. So I would ask that in future we ask the clerks to make sure a small map is produced to ensure that we can understand where the areas are, especially when there's 27 of them. So if the committee has agreed that there are no comments as to whether it should happen, is the committee happy that we write to the Highland Council regarding enforcement? Okay, so we are agreed on that. Thank you. Okay, the next item of business is stage 2 of the Land Reform Scotland Bill, and this is consideration of the amendments, and I'd like to welcome the non-committee members who are here today. This is our first Stage 2 meeting, and the Stage 2 deadline at the moment is the 27th of June, but we've had over 516 amendments, which will require some consideration. Now, before we go into the detail of those amendments, I would like to remind members at the outset that I've always made a declaration at the start of these that I have an interest in a farming partnership in Murray, as set out clearly in my register of interest. Specifically, I declare an interest in the owner of approximately 500 acres, or for those of you that want to do the conversion, it's 202 hectares of farmland, of which 50 acres is just over 20 hectares is woodland. I also declare that I'm a tenant of approximately 500 acres, approximately 202 hectares in Murray under a non-agricultural tenancy, and that I have another farming tenancy under the Agricultural Holdings Scotland Act 1991. And I also take on grass lets on an annual basis should I need to. So that's my interest declared at the outset. Now, it's going to be hard to predict how much progress we'll make, but I think I can say with some confidence that I don't expect us to get past section 6 today. What I would also like to say that just from the committee's point of view, that I'm looking to stop the proceedings on stage 2 at around 12:30 so that we have time to consider our work programme. Right, just to, as this is the first time we've done it in this bill, I just want to recap. So what you should have is for your working documents today, the bill, the marshalled list and the groupings. And for those of you watching online, those are available on Scottish Parliament's bill webpage for anyone watching. I'll call each individual amendment in the order of the marshalled list, and the member who lodged the amendment should either move it or say not move when it's called. If that member doesn't move it, or any other member present may do so. The grouping of amendments sets out the amendments in the order in which they will be debated. There will be one debate on each group of amendments. The member who lodged the first amendment in the group will be called to speak to and move that amendment and speak to any other amendments in the group. I'll then call the other members with the amendments in the group to speak, but not to move their amendments, and to speak to the other amendments in the group if they wish. I'll then call any other members who wish to speak in the debate, and if you wish to speak, either indicate to me or to the clerk, but to one of us to make sure that I bring you in. I'll then call the Cabinet Secretary to speak if she's not already spoken in the debate. And finally, I'll call the member who moved the first amendment in the group to wind up and press or withdraw the amendment in the group. If a member wishes to withdraw an amendment after it's been moved and debated, I'll ask whether any other member wishes, present objects. If there is an objection, I'll put the question on the amendment. Later amendments in the group are not debated again when they're reached in the marshalled list. If they are moved, I'll put the question straight away. Just to remind you that only committee members may vote in a division, and voting will be, because we're doing it a hybrid way, will be by roll call this morning. So I will go through a roll call to get your votes, and we'll then hopefully get a result there and then if the figures tally. And if we don't, we'll do the roll call again until it does, but it will do. So that's how it works. Now I'm going to move to the first part of the list. So can I just say this is a huge briefing pack for today, and it doesn't go past to today, so there's a lot more to come. So the first amendment I'm going to call Amendment 310 in the name of Ariane Burgess, grouped with amendments as shown in the grouping. Now, Ariane Burgess is at another committee meeting at the moment, and I believe Mark Ruskell is going to move the amendment and speak to all the other amendments in the group on her behalf. So, Mark, over to you.
Thank you very much, Convener. And yes, Ariane Burgess sends her apologies. She is, as members will know, Convener of the Local Government Housing Committee, and there is a Housing Bill Stage 2, which is concluding today. So I'd like to speak to 310, and I'll speak to other amendments in the group. I've got a few initial comments to make on this. So I think we're all aware that Scotland is very much an outlier compared to many European neighbours. Ownership of land is hugely concentrated, and of course this bill is delivering the next step in land reform. But any land reform legislation must deal with private property rights, so it is crucial that the process is underpinned by the concept of the public interest. Now, this is a widely used term in Scottish and UK legislation, with over 200 mentions in primary legislation, including existing land reform on community rights to buy. And the concept of the public interest is also widely accepted in international law. It forms an integral part of the protection of private property within the European Convention on Human Rights, Article 1, Protocol 1, which says that no one shall be deprived of his possessions except in the public interest. So Parliament and Government can curtail that right in particular circumstances, provided they're set out in law and that they're in pursuit of a legitimate aim and are proportionate. And these circumstances are, in many forms of legislation, determined by a public interest test. Now, in this legislation, questions of addressing the public interest, the ownership of land, have been quite inexplicably avoided. With a transfer test, and lotting decisions being determined by the impact of that specific landholding upon community sustainability. A concept that implicitly dealing with the public interest, but which remains quite poorly defined with no apparent legal precedent. As such, centering the public interest rather than community sustainability is a far stronger legal position and is likely to establish clearer precedent to avoid future legal challenge, as research from Scottish Land Commission has made clear. Now, this raises the question as to why the Government have not explicitly engaged with public interest considerations despite the SLC's recommendations and the Government's own consultation clearly framing a public interest test. As it stands, the bill provides little clue or definition as to the relevant public interest considerations in the ownership of land. The bill needs to consider the public interest in both the sale, ownership and management of land. So Amendment 310 seeks to place a public interest considerations on the face of the bill. This will ensure predictability, transparency and coherence for landowners who will be producing land management plans and potentially engaging with a transfer/public interest test. If this amendment passes, then landowners will be producing LMPs based on public interest considerations that would also underpin any assessment if they were to buy or sell land over the threshold. I'd like to thank Community Land Scotland for their support in preparing this amendment on behalf of Ariane Burgess. Turning to other amendments in this group. Take a brief intervention,
I thank Mark Ruskell for taking this intervention. It's just, does he accept that there's often a conflict between public interest and community interest? In the example of a wind farm, for example, that may be in public interest when it looks at maybe a just transition to net zero, but might not be what the community wants. And how would you think that we would balance those two interests?
Well, I think we'll come on to Mr Lumsden's amendments later on in this session, where I know his focus is explicitly on electricity infrastructure. I think the point he makes is why defining the public interest in this bill is really important. And of course, there is a wider public interest in terms of national infrastructure. There's community interest as well. But to simply have no definition of the public interest on the face of the bill, I think, is a mistake. And therefore, the point he makes really about a community interest being something of which there is little legal precedent, I think, is perhaps well made. But I'm sure we'll come on to his particular interest later on in this session this morning. If I could turn then briefly to other amendments in this group. So 339 from Rhoda Grant and 174 from Mercedes Villalba also seek to include public interest considerations on the face of the bill, specifically on LMPs and the transfer of large holdings. And, we support these in principle, the Greens, though Amendment 310 is a more kind of holistic, joined-up approach to ensuring that public interest underpins all obligations in the legislation, but don't have a problem with those amendments in principle. 150 and 151 from Michael Matheson also introduce a public interest consideration for lotting decisions, and I'll be happy to support that. Tim Eagle's amendments do seem to work against the direction of travel of this bill, which is fundamentally about democratising Scotland's land ownership. I'm sure we'll have lots of conversations with Mr Eagle later on through his amendments, but it's not a direction of travel that the Greens will be supporting. And similarly, Mr Lumsden's amendment and in later groups seems to set limitations on land being used for the purposes of upgrading our energy system and its infrastructure. Now, I don't know if that's just about wind farms or if that's a concern about small modular nuclear reactors or fracking infrastructure or carbon capture and storage or Peterhead 2 or any other sorts of energy infrastructure, or if it's just about one type of energy infrastructure. But clearly it is in the national public interest to deliver cheaper, cleaner energy households really need. So I'll say at the outset we're not really going to be supporting those. So I think with that, Convener, I'll probably close my opening comments and wait to hear from other contributions from members who are moving and contributing to the debate.
Thank you, Mark. I'm now going to call Rhoda Grant to speak to Amendment 339 and the other amendments in the group. Rhoda.
Thank you, Convener. Amendment 339 places a public interest test on land management plans. This amendment would require landowners to consider public interest when pursuing land management plans. Owning large areas of land is a privilege, and therefore large landowners need to consider the impact of their activities on the wider public when drawing up their plans. Amendment 342 expands the definition of land subject to the obligations under Section 44A to include public interest determinations. It would also add public interest criteria for applying to land management obligations. It would allow government to impose public goods on large landowners. Too often we hear that communities can't access land for vital community interests such as housing and food production, and this empowers government to step in where community efforts have failed. Amendment 348 is a technical amendment consequential to Amendment 342 to include Section 44D in the list of relevant sections. I support other amendments in this group from Mercedes Villalba, Michael Matheson and Ariane Burgess. It's clear we need a public interest test on many aspects of the bill for the reasons laid out by Mark Russell, and I won't repeat them. And I look forward to hearing the Cabinet Secretary's thoughts on which amendment might best do that for the whole bill.
Thank you very much, Rhoda. I now call Tim Eagle to speak to Amendment 427 and any other amendments in the group. Tim.
Thank you, Convener, and good morning, everybody. Can I just draw members' attention to my register of interest as a farmer as well, Convener, before I start? Thank you to everyone at the Net Zero Committee for welcoming me this morning to speak to and move my amendments on the Land Reform Scotland Bill. My Amendment 427 seeks to add in a new section. It seeks to stop land being subjected to allotting decision if it would not be in the public interest for allotting decision to be made in relation to the land. It also allows ministers to make further determinations under that amendment. My Amendment 433 adds in a further part to the allotting provisions. It allows ministers to buy land subjected to allotting decision if they are satisfied it is in the public interest to do so. In addition, Amendment 433 sets out that such an offer must be at market value. My Amendment 460 requires regulations made under these parts to be subject to a Section 98(5) of the 2003 Act. That means that any statutory instruments made under these parts must be laid before Parliament and approved by the Scottish Parliament. Finally, in this group, I will be supporting my colleague Douglas Lumsden MSP's Amendment 364. As a member for the Highlands and Islands, I know of the very deep concern that many of my constituents have about the number of pylon applications across Scotland.
Thank you very much, Tim. I'm now going to call the Deputy Convener, Michael Matheson, to speak to Amendment 150. I'm only going to say the Deputy Convener once, because I think you've got lots of time to speak, but we all know who you are. Michael.
OK, thanks, Convener. I'm going to speak to Amendments 150, 151 and 158 that are in my name in this group. During the course of the evidence sessions we received on this bill here in committee, it was clear that there was a strong desire to see the term public interest to be on the face of the bill, given that there is precedent elsewhere in Scottish legislation. The main purposes of Amendments 150, 151 and 158 is to address that point and to make public interest considerations clear and upfront on the bill. They also make clear that ministers will be able to consider other elements of the public interest when considering whether to require lotting to be undertaken. Amendment 150 in itself inserts a new subsection at the outset of inserted section 67N of the Land Reform Scotland Act 2003, which clarifies the powers to require that the land be sold in lots may only be used where ministers consider that doing so is in the public interest. Amendment 151 amends again the inserted section 67N1 of the 2003 Act to provide that the lotting decision will not be in the public interest unless the test which is set out in the subsection is being met. And Amendment 158 is to amend the inserted section 67R, again in the 2003 Act, to update the cross-reference relating to the Amendment 150.
Thank you very much, Michael. I now call Mercedes Fialba to speak to Amendment 174 and any other amendments in the group. Mercedes.
Thank you, Convener. Good morning, Committee. I'm pleased to speak to Amendment 174 and my other amendments in the group, and I would like to thank Community Land Scotland and the Scottish Parliament legislation team for their support in drafting these amendments. The bill, as introduced, includes a transfer test, which does not make any assessment of the wider public interest in land ownership, nor does it assess whether the buyer or their plans for the land meets the public interest. Successive Scottish governments have made consistent commitments to diversifying land ownership patterns in Scotland, but as it stands, the transfer test in this bill is not an effective mechanism for achieving this. In order for a test mechanism to be impactful, it must move beyond a mere assessment of the landholding and also make a forward-facing assessment of whether the landholding and the incoming landowner's land management plan will meet the public interest. This would also add coherence between the otherwise disconnected test and the land management elements of the bill. This committee heard in evidence from numerous stakeholders, experts and land users that it was necessary to reframe this transfer test as a public interest test. And the committee's Stage 1 report noted how it considers the current transfer test will not meet the aims of the Scottish Government as it does not sufficiently take account of the public interest. Unlike the term community sustainability in the bill, the public interest is widely used in Scottish and UK legislation, with over 200 mentions in primary legislation, including existing land reform legislation. This means a public interest test is likely to establish clearer precedent than a transfer test and would avoid future legal challenge. And research for both the Scottish Government and the Scottish Land Commission have been clear on that. Amendment 174, in my name, therefore inserts a forward-facing public interest test into the bill to be applied to a proposed new buyer in relation to transfers of large landholdings. Under this proposal, land being transferred will remain subject to public interest considerations and existing obligations, such as land management plans, whilst ensuring potential buyers fulfil land management plan obligations necessary for their ownership of the land. Both the public interest test in Amendment 174 and public interest test as amended with a presumed limit in 174A provide that a proposed transfer where Section 67G and a lotting decision under 67N applies to the land has no effect if ministers consider the transfer test would not be in the public interest. In doing so, I'll just continue with this and then I'll take an intervention. In doing so, ministers must consider matters about the buyer laid in the amendment subsection 2, namely where the landlord is tax resident, the size and location of any other land the landlord controls, plans and proposals for land management, and their future plans for the use or sale of the land. By having a public interest test which assesses whether the landholding and the proposed purchaser are working in the public interest, that forward-facing burden, including lotting, is placed on the transfer. As lotting is defined as in the public interest, the amendment would not violate a property owner's rights. This is what's been described as a fit and proper person test to ensure that the owners of Scotland's land who manage it, who buy it and who sell it are going to do so in the public interest. And I'll take the intervention from Douglas Lumsden.
I thank the member for taking the intervention. It's just around the amendment where it says that where the person is resident for tax purposes. So can the member just expand a little bit more on what is intended there? Would that mean if someone lives in a different country, for example, would that rule them out of purchasing land, even though they were maybe going to be investing substantial amounts in Scotland? Or would there be some other mechanism where it would be decided whether that would rule a person in or out of purchasing land?
Yes, well, as I said, the tax residency of a proposed buyer would be a consideration under the public interest test. But it's not enough to address the concentration of ownership. We also need to address the scale. because today Scotland's land is concentrated in the hands of the new nobility, asset managers, foreign billionaires and the inheritors of huge estates. Just 0.025% of Scotland's population owns 67% of our countryside, and this bill presents a chance to change that. That's why my Amendment 174A extends the public interest test to include a presumption against private land ownership over 500 hectares unless it can be demonstrated to be in the public interest. Large landholders which own land for the public benefit, such as environmental groups, community organisations and public bodies, should be confident that by definition their ownership would pass a public interest test. But the extraordinarily high concentration of land in the hands of so few is severely limiting access to affordable homes, stifling job creation, increasing land prices and harming the environment. So it must be addressed, and that's exactly what Amendment 174A does. This proposal to cap ownership was included in the consultation for my proposed Land Ownership and Public Interest Scotland Bill, which garnered 568 responses, which is more than the Scottish Government's own consultation, and the response was overwhelmingly positive, with a majority of support for a presumed limit on the amount of land that any person can own. Finally, Amendment 174B seeks to place public interest considerations on the face of the bill in order to underpin a public interest test, which will ensure predictability, transparency and coherence for landowners engaging with the public interest test. And Amendment 459 introduces the provision for Scottish ministers to compulsorily acquire land after a failed public interest test. Ministers would be granted the power to compulsorily acquire some or all of the land which fails the test if it would be in the public interest and more likely to secure true sustainable development of the area. This sustainable development must equally and fairly balance all interests, including worker, community, natural environment and biodiversity considerations. Thank you.
Thank you very much, Mercedes. I now call Douglas Lumsden to speak to Amendment 364 and any other amendments in the group.
Thank you, Convener. Just to talk to 364, first of all, there is a big issue across Scotland now where communities feel ignored and feel overruled when it comes to so much electricity infrastructure that we're seeing pop up right across the countryside. Now, I think it's only right that we try and address that within this bill to really allow communities to have a say. And if communities want battery storage, for example, and if there is proper community benefits and if there's jobs and the community embrace that or even have part ownership of that, then I think that should be welcomed and should be encouraged. But where we have communities so strongly against things that are happening in their communities, I think we need to address that. And I think that's the aim of this bill, to be honest. So I think we should be listening. And that's what my amendment aims to do. If there is a strong community objection to electricity infrastructure in that area, then we should be listening to them and we should take in that views on board. And I think that boils down to some of the questions I've already been asking. Between public interest and community interest, they are not always the same thing. There's often conflicts within that. And even within some of the descriptions of public interest that we've seen laying before us today, there's conflicts. One I can see there between food security and a just transition. So, a lot of the time we're seeing good farmland being turned over for solar panels, for battery storage, so it's just to highlight there is often conflicts within the public interest definition that's been laid before us. I'm just going to talk to one other amendment, and that was 174 in the name of Mercedes. Of course.
Before he moves on. Sorry, my microphone's on now. I thank Douglas Lumsden for taking the intervention. I think in an earlier discussion with Mark Ruskell, you made reference to net zero. And I hear the distinction you make between public interest and community interest, and they might not add up to the same thing. But in this current climate where we have some politicians using slogans like net stupid zero, and there's a lot of misinformation flying around, does the member agree that it's really important that decisions are rooted in evidence and in science, and that sometimes community campaigns can be distorted because of misinformation that's flying around? So I hear the points that he's making, but does he recognise concerns that some decision makers have, that sometimes community voices can be quite loud, but they're not always reflecting the public interest and the genuine community interest.
I hear what Monica Allen is saying, and there is misinformation there, and I think that we should do everything we can to try and stamp that out, and that decisions should be based on evidence. But when it comes to community groups being loud, yes, some of them are loud, because a lot of them are quite angry at what they're seeing on their doorsteps, and they're not feel that they're being listened to. And this is what I think we need to do more around that. I think if we can bring communities with us on our journey to net zero, then I think that's a win for all of us. But I don't feel that that's happening just now, and that's why I've brought forward these amendments. Of course.
The intervention in relation to this, convener. I just wonder, Mr Lumsden, whether or not there's a definition of local community and whether there's a certain scale. Would a cluster of 5 or 6 houses near a proposed development count as a local community? Would it be a wider area? Because we could have a situation where a relatively small amount of people with a theoretical population density in a remote area could block quite a large development. Is that the intent of this amendment?
It's not the intent, but I think however large or small a community group is, they should be listened to. I don't think we could say that because it's just a small community group that they should be ignored. They could be impacted the most. And if developers could work with even those small communities better, then I'm sure a lot of the issues we're seeing right across Scotland wouldn't be happening. Moving on to 174 in the name of Mercedes Villalba, I did ask the question there about what it actually means if somebody was not resident in this country for tax purposes. Would that mean that they were ruled out of making a purchase or not? And I wasn't quite clear from the intervention, the answer I got. So I think that's probably quite a dangerous line to go down unless there was clear clarification, and I don't feel that we have that. And on that, I'll leave my remarks there, Convener.
Thank you very much, Douglas. Does any other member wish to say anything? I do, but I'm interested to see if anyone would like to go before me. No, okay. So, if I can just say at the outset, I'm talk about amendments 310, 339, 150 and 174 regarding public interest. I understand, and I've heard during the course of the Stage 2 debate about the need for public interest. And my concern is that the list of things that in Amendment 310 regarding public interest, actually in Section 2 of 310, cause a certain amount of conflict. And when you are drawing up a management plan, if you are the owner of land, you cannot keep everyone happy, that is for sure. And you cannot afford to do everything that everyone wants to do. And there is no definition or clarity in any of the amendments that are put forward on public interest about who is going to pay the person who is delivering that public interest and whether that person should in fact be rewarded for that public interest. At the moment we have a system where there are agricultural subsidies which are paid in relation to achieving various aims, and without any doubt I will put my hand up and say that I'm in receipt of agricultural subsidies for delivering public good in relation to the production of food. But if you looked at 310 and looked at that is Amendment 2K is about contributing to food security and food system resilience. And then if you look at that, also looking within there is a requirement for diversity. But the problem is that sometimes intensive grazing of land to create food security is the best way forward, but it might not be in the government's interest. So the government are managing at the moment and struggling to come to terms with the advice of the Climate Change Committee on whether to reduce livestock numbers across Scotland by 30%. That may destroy farms and farmers who cannot have the scale to carry out their business. So I am concerned, and I don't think any of the tests that have been put forward under 310, 339, 150 and 174 define how public interest and delivering it will be rewarded. Yes, I'll take an intervention from Mr. Ruskell.
Thank you for giving way. I'm just thinking about what you're saying here about, those in receipt of subsidy. I mean, as somebody who is in receipt of subsidy, do you think you're receiving that subsidy to deliver the community interest? because that is what is in the bill at the moment. It's about a community interest test rather than a wider public interest test.
Thank you. I don't think people who are receiving payments at the moment under the Farm Payment Scheme are receiving it from necessarily for community good. They're receiving it to cover the regulations that's required. So passports for animals, the livestock density, the stocking rates, the use of fertiliser and when it can be used on land. Those are the sort of things that people are getting. You are going beyond this, or the suggestion in the amendments is to go way beyond this in the public interest. And therefore it gives me some concern that we are putting burdens on people who are not going to be rewarded for doing it. I listened carefully to the amendments put forward by Mercedes Villalba regarding tax residency. I'm not sure I understand where you have to be tax resident to own more than a certain amount of land. Is that in Scotland or is that in the United Kingdom? Obviously there are two different tax rates for those people and different tax codes indeed to show whether you're resident in Scotland or the United Kingdom. So I'm not sure that that amendment in itself would be competent because I don't understand where it would be. As far as environmental groups owning, yes, I would take an intervention. Mercedes.
Thank you. So can I ask what the member's position is on the principle of who owns Scotland, and does he think that it's right that anyone anywhere in the world with enough money can own Scotland while many people here don't have access to the land?
Thank you. I think my view is quite clear, is it's more important what they do with the land than who actually owns it. And, you know, in the past I've worked for people who brought a huge amount of money into Scotland and invested in Scotland, used local firms to do all the work. That to me is good, and also delivered on the things that the governments require, like public access and deer management plans, all of which are. So I'm completely without opinion on who owns it, but it's the way it's managed and run that actually matters to me, and whether it delivers what the government is trying to achieve. Yes, Mercedes, of course.
I suppose, for me, it's a point of democracy and accountability, and the extent to which the individuals that you refer to, how are people in Scotland able to hold them to account if they are not managing the land appropriately. Whereas if they are based here, have skin in the game, are contributing through taxation, then they then have, one would assume, greater stake as to what happens and the decisions that they make. They have a greater impact on them, their families, their communities.
Thank you. Actually, I'm afraid I disagree with you there. Let me give you an example, if I may. A fairly large brewing company that owns land just south of Aviemore took millions of pounds from this government to plant trees, which then all failed. There is no accountability locally for those people who when they took over that estate, made 5 people redundant and have created a bit of a desert while they're doing their management, and there's been no feed into that management plan. So I don't believe it's where you are, where you live. I think it matters what you're doing with it, and I think that can be controlled by regulation rather than just basing it on ownership. And I am going to move on from that. It's a great conversation, which I'd love to continue elsewhere. As far as environmental groups are concerned, owning more than 500 hectares, I have to say I have huge concerns about that. I don't think environmental groups who own over 500 hectares are also the paragons of good land management when it comes to management of land across Scotland. I can think of some groups that, again, have taken millions of pounds to increase certain species, like, for example, the capercaillie, and have overseen the decline of capercaillie on that land. So just because they've got more than 500 acres, because they're an environmental group, that doesn't work. The other issue I had with one of the points that was brought up was regarding compulsory purchase. There was no definition to me on how it would be compulsory purchased, whether it would be used using the Compulsory Purchase Act, and how then the valuation of that land would be placed. Is it the compulsory value of the public interest, which is going to be in this, or is it the public, or the value, the open market of the land? And I think there are various problems within that. Now, Mercedes, I will always give way on subjects to do with land reform to you.
Thank you, Convener. Well, if it's just about the the detail of the amendment, but the member supports the principle of compulsory purchase, then be happy to work with him in between stage 2 and stage 3 to bring something back, if that's the only issue.
I would be happy to talk to Mercedes Vialba about how compulsory purchase could be done where it's clear that there is bad land management practices, providing it wasn't limited to private landowners, included environmental groups as well. So if it was broad spectrum, I'm happy to work with on that. I have no other comments. Those are my concerns with the amendments. Unless anyone's got anything else to say, I'm going to move to the Cabinet Secretary. And Cabinet Secretary, the floor is yours.
I want to thank members for all their contributions to the debate on this grouping, because I think we are talking about really important matters. And I think it is clear that, well, broadly, I would say across the committee, there is that strong desire for the public interest to be at the heart of the decisions that we take. I think there are also a wide range of views as to what that might mean and what that could look like. And I have listened carefully to, I think, the really clear views that have been expressed by stakeholders and the committee that the transfer test that was set out at the introduction of the bill should take greater account of the public interest. And also, in my evidence in response to the committee's Stage 1 report, I was clear that any reframing of that test would have to be consistent with the evidence base for the proposal, which has highlighted the really damaging impact that concentrated land ownership can have on the sustainability of local communities. So that's why I welcome the amendments that have been put forward by Michael Matheson, amendments 150, 151 and 158, because these amendments make it clear that ministers will only require land to be allotted where they consider that it is in the public interest to do so, while remaining consistent with the evidence base that we have. Now, Amendment 3... Yes?
I thank the Cabinet Secretary for taking an intervention. Does the Cabinet Secretary agree with me, though, that public interest and community interest aren't always the same thing? And there's often a conflict between community interests and what may be put down as for public interest. You know, we'll use the example of a wind farm, for example, and there may be conflicts between the two. And how would we address those?
Well, the community views are, of course, hugely important. I'm going to turn to this in my speaking notes too. But that's where the mechanisms that we have to deal with these processes and ultimately through planning are so important in ensuring that we are hearing those views come through. Now, in turning to Amendment 310 from Ariane Burgess and Amendments 339 and 342 from Rhoda Grant, they seek to introduce a definition of the public interest on the face of the bill for various purposes. And I think while I support the aims that are referred to in relation to those definitions, I don't think that it's necessary or helpful to attempt to define the public interest in the bill in that specific way. And that's also consistent with the opinion of the Court of Session, with Lord President Gill and Parkcrofters Limited versus the Scottish Ministers, who had noted that the public interest is a concept that is to be found throughout the statute book. There's no need for a general definition of it. It's for the Land Court and the Ministers to assess the public interest on the facts and circumstances of the case, and a general statutory definition of the public interest, if one could be devised, would be unhelpful. It's unclear how exactly Ministers or landowners would be expected to fulfil that duty that's set out in Amendment 310. It would require Ministers and other public bodies to have regard to the public interest in land reform, but of course that includes many objectives listed in the amendment too, and guidance made by ministers in relation to any function in a wide range of legislation, much of which isn't even related to land reform. Yes.
Thank you, Cabinet Secretary, taking intervention. I was interested in the point there around the case law that effectively has come through the Land Court in relation to defining the public interest. Can you say more about what that case law has shown in terms of the legality of a public interest test?
I mean, I'd be happy to share more information with Mark Ruskell as well as committee members more broadly. But I mean, ultimately, I think, and I think Mercedes Vialba had referenced this in her comments to just how widely we have referred to public interest specifically in legislation. But it's, and what we have tried to do in relation to the land reform bill that we've got in front of us is that obviously we can't just state public interest. I feel like what is set out in Amendment 310 is very descriptive, and again, as I've set out from the reference from that case law, it's too descriptive, and having a definition which I feel like restricts how that could be interpreted, I don't think would be helpful. Yes.
I can understand to an extent where she doesn't want a description of the public interest in the bill, but surely a reference to it in the face of the bill, that the whole bill is carried out within that framework, because that is the framework that can be that is understood legally. Would she look at introducing an amendment in discussion with those that have put forward amendments today that would actually cover the whole bill, so that all the actions under the bill would be taken in the public interest?
I mean, I think that when we introduced the bill, obviously the transfer test which we had set out, which didn't explicitly state public interest, was framed very much in the way because, just as Mark Ruskell talked on earlier, that when we reference or when we're justifying interference with property rights or any interference with A1P1, we need to make sure that it's proportionate, it has a legitimate aim, we have the evidence base for that intervention as well. We had framed the transfer test, or it essentially is a public interest test, and that's why I'm agreeing to the amendments that explicitly state that here, because we have to qualify that and set out why it works in the way that it does. So again, I think I can't agree with Amendment 310, I think, in the descriptions that it has there. I would have to take advice and see exactly what the implications of a suggestion, the likes of what Rhoda Grant is suggesting this morning. But I do feel like it's something that we potentially wouldn't be able to support, and that's why we're happy to support the amendments that have been set out by Michael Matheson, and because of the framing of those. I'll continue to make progress, Convener. This amendment would put duties on Scottish ministers and other public bodies for purposes completely outside the scope of this bill. Such substantial alterations to public decision-making shouldn't be made without more detailed consideration and consultation. There are also serious issues with Amendment 339, which is a departure from the policy aim of land management plans to improve transparency and engagement between landholders and communities. This amendment would create a really complex and potentially quite confusing landscape for the landowner when preparing a plan, and risking those plans becoming a box-ticking exercise. Amendment 342 attempts to provide ministers with powers to amend definitions of land that community engagement obligations would apply to, and this can already be delivered through existing powers in the bill to update definitions of land through regulations. So that's why I would ask members not to support Amendments 310, 339 and 342. I would also ask members not to support Amendment 348 because it's consequential to Amendment 342. And turning to Amendment 427 from Tim Eagle, that would allow ministers to determine that a lotting decision was not required if this was in the public interest. Now, for ministers to be able to make that assessment, they would need to consider information about the landholding and determine then if lotting would be beneficial or not. So this is the same information that they would need to consider to make a lotting decision. So it's already the intention that transfers are able to be screened out more quickly when that's appropriate. So I know that Michael Matheson is bringing forward Amendment 156 that will allow for further guidance to be set out on how that screening is going to take place. So that's why I would ask members not to support Amendment 427 and Amendment 460, which is reliant on that. Amendment 174 from Mercedes Villalba, which is further amended by her amendments 174A and B. We would introduce a test on buyers of land as well as a presumed limit on land ownership over 500 hectares. Now, this amendment is a significant departure from the current bill and isn't supported by the evidence base. It would give ministers a mechanism to entirely block proposed transfers in a wide range of circumstances based on their own assessment of the public interest or evaluation of the buyer. And the interference in property rights that would result from these proposals would require a rational and coherent justification based on evidence. And the evidence on which I've proceeded is concerned with the effects of concentration of ownership on communities, and there isn't that rational link between that evidence and the proposals that are set out in these amendments. Yes.
Sorry. Thank you, and thank you for giving way, Cabinet Secretary. One of the things that you have been quite careful of, and the evidence we've heard, is to make this land reform bill proportionate so that you avoid legal challenge. Do you suggest that Mercedes Villalba's suggestion of 500 hectares would lead to a legal challenge, which would, because it would interfere with people's human rights?
Well, there is a significant interference there with property rights, and I don't believe that we have the evidence base there to connect it, which is my serious concern with this amendment. But I do have other concerns in relation to if it were to pass, and just as I was turning to, there would also be quite significant resource and financial implications for the Scottish Government as a result of this amendment, should it proceed. So, for those reasons, I would ask members not to support Amendment 174, the related amendments to that, and Amendment 459 is dependent on 174, so I would also ask members not to support it. In turning now to Amendment 433 from Tim Eagle, this would allow ministers to offer to buy land before making a lotting decision. So this would be a departure from the bill as it's drafted, because it's unclear how public purchase in this way would reduce concentration of land ownership. Now, ministers and public bodies already have powers to purchase land by voluntary agreement where that's justified, and the bill as introduced also allows ministers to offer to purchase land in certain circumstances following a review of lotting decisions. So I would therefore ask members not to support Amendment 433. And I think turning now to Amendment 364 from Douglas Lumsden, which relates to transfers for electricity infrastructure. First of all, I just want to outline a few comments to committee, because this is a matter of interest to my own constituency at the moment, and I want to make clear that I'm appearing before the committee today in my capacity as a Minister of the Scottish Government, and the position that I'm presenting reflects the collective view of Scottish Government and concerns a matter of law and policy for which I have ministerial responsibility. And separately, and in line with the Scottish Ministerial Code, I've made my views and those of my constituents known to the responsible minister in the appropriate way. However, the issue under discussion today is distinct from that constituency interest, and my contributions today should therefore be understood as reflecting the government's position, not a personal or constituency-specific stance. Now, Amendment 364 from Douglas Lumsden is unrelated to the provisions of the bill as introduced. It would block voluntary transfers of any land, so that's not just land that forms part of a large landholding for the purposes of constructing electricity infrastructure. This would be an interference with the owner's property rights, and again, the justification isn't obvious from the amendment, especially as the amendment would not appear to address what are the main legal mechanisms by which electricity infrastructure is actually delivered, such as under the Electricity Act 1989, which is UK government legislation relating to reserved matter. So with that, I would ask members not to support Amendment 364. Thank you, Convener.
Thank you very much, Secretary. Now, we're in the opposition that Ariane Burgess's amendments were actually moved by Mark Ruskell, but Ariane now has finished her committee. But I think, Ariane, we've agreed that Mark Ruskell will sum up your amendments and move your amendments in your name. So please don't take it as a slight that I'm ignoring you. I know you're here. So, Mark Ruskell.
We're of one mind, so we will channel it. I think an interesting debate, and I think what I take out of this is, Mercedes Valalba's contribution really underlined the huge imbalance that we have, the obscene imbalance that we have in land ownership in Scotland, and that fundamental case for reform is nowhere is not addressed in this bill. It's absolutely nowhere. So, although I'm supportive of amendments that you're bringing forward, Ms Valauba, I don't see the majority in this committee or in this Parliament, and I think that's very sad. And I think we're going to need a major piece of land reform legislation, possibly in the next session of this Parliament, to start to really address those fundamental issues. But anyway, let's turn to the bill we've got in front of us. I think an interesting debate about what constitutes the public interest. And there's different flavours of that are in front of the committee here this morning. And I think some aspects of that argument have been taken on by the Cabinet Secretary, and I certainly thank the Cabinet Secretary for the conversations that you've had with Ariane and myself and my group around this. And I'm sure that has resulted in part in the amendments that we will be supporting from Michael Masson in relation to lotting. But it doesn't really fundamentally address that issue of where the public interest sits within the bill, and quite frankly, what is currently an inadequate definition of the public interest that's wrapped up in this definition of community interest. And I'd be interested to see how that definition is considered within cases that have come to the Land Court and elsewhere. Maybe that's something we can think about in our long summer recess. So I think there's still some mileage to go. I mean, take on board, concerns about, particular, definitions of public interest in 310 and in other amendments. But I do think there's a conversation that needs to be had, certainly between, Labour, Rhoda Grant, the Cabinet Secretary, and myself, Ariane Burgess, and Michael Masson and others around, how we better interpret that public interest within the bill in stage 3. In terms of that community interest, I mean, it's clearly, the debate here this morning has been about, anti-wind farm groups are they the community? I don't know. They possibly might be in some areas, but that term does not have a strong legal definition. It's widely interpretable. And I don't think is a strong basis to go forward. I think what Mercedes Valab also said is that there needs to be this forward-facing burden, and I think that's what we need to focus on ahead of stage 3. How do we put more of a forward-facing burden onto landowners that represents that public interest? I think there's space for more conversation here. At the end of the day, this is a land reform bill. It's not a planning bill, so if there are other issues around community concerns about development or whatever, this really isn't the place for it. But I do think there's something there around the public interest that could emerge from further discussion. I'll leave my comments there, Convener.
Thank you. Can I ask you whether you wish to press or withdraw Amendment 310?
We do, yes. I will be moving 310.
So you're pressing Amendment 310. Thank you. Okay. The question is that Amendment 310 be agreed. Are we all agreed?
Yes.
No, we're not. There will be a division. Therefore, I will do a roll call of votes. So I'm going to ask you if you're for, against, or wish to abstain. And I'll start with Bob Doris. For?
Against.
Against. Mark Ruskell?
For.
Monica Lennon?
For.
Michael Matheson?
Against.
Edward Mountain says I'm against. Kevin Stewart? Sorry, I can't hear you, Mr. Stewart.
Against.
Thank you. And Douglas Lumsden?
Against.
Thank you. There are 2 votes for the amendment, 5 votes against. There are no abstentions. Therefore, the amendment is not agreed. Now, I'm going to call Amendment 10 in the name of Tim Eagle, grouped with amendments shown in the groupings. And I want to remind members of the preemption and direct alternatives in this group as set out in the groupings. Tim Eagle, can you move Amendment 10 and speak to all the amendments in the group, please?
Yes, thank you, Convener. I move Amendment 10. And before I start, just a touch base on something Mark Ruskell said earlier on. I completely respect, actually, there's quite a wide amount of views around this room, but I think it's fair to say that, as I tried to lay out in my Stage 1 speech, I'm not overly supportive of the direction of travel of the bill overall. So I just want to put that into context, because obviously a lot of what I say and a lot of my amendments, I agree with, I think, the point the Convener made, that actually, to me, it's not so much about the ownership of the land, but the management of the land that comes into, and certainly my own experiences in this field have led to that. But moving on, my Amendment 10 requires ministers to provide guidance on the meaning of engagement with communities and to define what constitutes communities in terms of Section 1 of the bill. As currently drafted, the bill contains the wording engagement and communities, which both have wide connotations. This leaves the meaning unclear. The wording used is rather generic and does not refer to a particular group or geographic proximity. If landowners are to be fined for their failure to consult, then they need to know exactly who they are supposed to consult with. This amendment would require additional guidance to be provided to ensure that remains clear. My Amendment 390 removes the requirement in the bill for land management plans to be made publicly available. There are 3 reasons why this amendment should be taken forward. Firstly, it seems inappropriate for commercially sensitive information about individual businesses to be made public. Secondly, there is already a vast amount of information already publicly available. The bill, as drafted, could lead to duplication of that information. And thirdly, landowners, particularly farmers, need assurances regarding commercially sensitive information. My Amendment 18 seeks to delete lines 9 and 10, which require the owner of land to engage with communities on the development of and significant changes to the land management plan. We do not believe it is feasible for landowners to consult with the community when developing or making significant changes to the plan. We therefore propose to remove this. As currently drafted, the bill requires, through regulations, for obligations to be put on the landowner. This includes engagement with communities on the development of and significant changes to the bill. My Amendment 391 and the consequential Amendment 392 changes the reference to communities from that to a community body within the vicinity of the land. The current use of the wording communities is generic. In contrast to other sections of Part 1 of this bill, this section requires consultation with the generic term communities without reference to any particular group or geographic proximity to the land. This is therefore potentially very wide and vague. Landowners can be penalised and fixed sums for breaching the duty to consult, so the duty needs to be framed clearly on the face of the bill. I believe this amendment would be resolved by using the amendment. My Amendment 19 removes the requirement for landowners to engage with communities when there will be significant changes to the plan. It would leave the requirement to engage with communities for the development of the plan. Following Amendment 18, we are particularly concerned about the responsibility on the landowner to engage with communities on any significant changes to the land management plan. We do not believe this is feasible for a landowner to be able to do this. Whilst it would be our first preference to remove this full requirement, this second option would remove our biggest concern. I now turn to my Amendment 21. The bill as drafted requires the land management plan to be reviewed and revised every 5 years. We believe that it is fair that land management plans are reviewed and kept up to date, but the period for review should allow greater flexibility given the wide range of land holdings and land uses that will be affected. It is not entirely clear from the bill what is meant by review, whether this will be a full community consultation. Cabinet Secretary, perhaps you can set out the intentions, and I would argue that this should be clarified on the face of the bill. We do not believe it is feasible to review this every 5 years. The review process is costly. I believe that estimates were given during the committee's stage 1 of a cost of £15,000, and the plans are supposed to project the long-term future. It may also be disproportionate if there has been any significant change in circumstances. Therefore, we believe this period should be extended to 20 years. I note Rhoda Grant's MSP's Amendment 315, which seeks to review this period of the land management plan from 5 to 10 years, and whilst I would prefer 20, we will support the amendment as 10 years as an improvement on 5 years. With regard to my Amendment 23, the bill as drafted allows for regulations which impose obligations on the owners of land. This includes requiring them to produce a land management plan in relation to the land. Amendment 23 seeks to ensure that a new owner is not required to produce a plan immediately on acquiring the land. It ensures that they do not need to make a plan publicly available until 1 year after they have owned the land. This would ensure the requirements of a plan is not a deterrent to new entrants and a financial burden on new owners, and would allow the new owners time to get to know the land before being bounced into producing a new land management plan. My Amendment 396 seeks to add to the list of what regulations allowed under 44A impose. It seeks to deal with a situation where a community body or individual member is acting unreasonably when the landowner is attempting to engage with the community for the purpose of 44B1B. It allows for that to be reported to the Commission and for the Commission to discharge the obligation to consult with the community under 44B1B. This amendment seeks to ensure that where the landowner is attempting to follow their obligations and a community body or individual is making that challenging, the landowner is not considered to have breached their obligations or required to continue attempted engagement. This protects the landowner where they have tried to follow through with their obligations. Now, with regard to other amendments in the group, while we support Bob Doris MSP's Amendment 16's aim to increase accessibility, we do have concerns about the costs here. I would like to know more about how much this would cost, who would be paying for the land management plans to be accessible. We will not be supporting Ariane Burgess's Amendment 311, as it is counter to one of our own amendments, Amendment 390. We seek to restrict the amount of information that is available to the public, as there is already a vast amount of information publicly available. Neither will we be supporting Rhoda Grant's MSP's Amendment 312, which seeks to prescribe the format of the land management plan, as we believe that this will add unnecessary extra costs onto landowners and prevent them from saving money by using plans they may have drawn up for other reasons. We disagree with Bob Doris's Amendments 17 and 31, requiring that land management plans are published online by a Republic body. There is already a vast amount of information already publicly available. We do not want to see duplication of that information. NFUS have raised significant concern about making commercially sensitive information about an individual business. Farmers and landowners need assurances regarding commercially sensitive information and that duplication is not required. Absolutely.
I thank Tim Eagle for giving way. I saw that NFU's concerns related to commercial confidentiality within land management plans. Now, within this bill, woven within this bill is the ability for various groups to contact the Land Communities Commissioner if they believe the obligation of their land management plans are not being met. If land management plans are not available, how on earth do we know whether the obligations of the land management plans are actually being met?
I think my concern, thank you for that intervention. I think my concerns here are around making sure that businesses are allowed to operate in a commercially sensitive environment rather than anything else. And I'm just picking up on the concerns that have already been raised by NFUS around that. We do not support Ariane Burgess's amendment, MSP's amendment 313, 314 and 316. As we feel that this will make the land management plans more onerous. We are putting forward an amendment to lessen the burden of their introduction, and this increases it and acts as a disincentive to innovation for farmers and landowners. We will not support the extension of engagement contained in Bob Doris's MSP's Amendment 20, as this takes us well away from the aims of the bill, which is community right to buy, and makes the consultee process too wide and onerous. With regard to Rhoda Grant's MSP's Amendment 335 on ministers appointing an independent person to create a land management plan for crofters, I would be interested to hear the Cabinet Secretary's response to this. We will not be supporting Bob Doris MSP's Amendment 33, which allows the Commissioner to publish guidance on how owners should comply with requirements set out in regulations, as we believe this provision would cause confusion and overcomplication. And with regard to Ariane Burgess MSP's Amendment 338, we do not feel able to support this amendment, as we believe it increases the cost of the burden of the land management plan. Finally, I'm interested in Rhoda Grant's MSP's Amendment 340, as there may be instances where the landowner may want to have a land management plan, and I am minded to support it. Thank you, Convener.
Thank you very much. I'm now going to call Bob Doris to speak to Amendment 16 and any other amendments in the group. Bob.
Thank you, Convener. I'll limit myself where I can to the amendments in my name only. First of all, Amendments 16 and 17 together make sure that land management plans are not only available, as is already specified within the bill, but also accessible. And in doing so, the plans must be published online by a public body to be specified under the regulations by Scottish Ministers under 44A within the bill. I think my view is that all land management plans must be accessible. That's very different from simply available, and hosted by a public body in the one place online, irrespective of which land management plan anywhere in the country an individual wish to seek to find. Not a needle in a haystack, but signposted clearly and searchable online. I have not specified which public body must be given responsibility for publishing them online, given I assume the Scottish Government would wish to discuss this with any public body being considered as the appropriate host site online for all land management plans. It may make sense for the public body to be the Scottish Land Commission, but the amendment is clear on the accessibility of the land management plans on an online platform, but not prescriptive as to the host. I also note there's an association amendment on 31 within Group 7, which we'll come on to later today or another day. Amendment 20 ensures that... Yes, of course.
Just a brief intervention. Did Bob Doris anticipate any costs arising from the amendments that he's bringing forward today on having another location for all the land management plans to be held?
Well, I think the costs associated to landowners would be in the development and publication of land management plans already exists within the bill as outlined. There's regulations within the bill that specifies the format that those land management plans must take, and then having an obligation to pass it in the prescribed format to the relevant public body really should have no costs at all. Now, I'll listen carefully to the Scottish Government and their position in relation to the costs associated to a public body and how that would be absorbed into the costs, the budget of that public body as matters stand, or whether those costs would seek to be recovered elsewhere. But I don't see any substantial costs in this at all. Amendment 20 ensures, and now move on to, ensures that in the development of land management plans that not only will communities be consulted, but there's also engagement with any tenants, crofters or small landowners with rights associated with the land on the development of and significant changes to the plan. As Community Land Scotland, who have worked with on a number of amendments here today, have noted to me, one example of where engagement would be essential is to where tenant farmers are required to produce whole farm plans as a condition of receiving support payments. This could conflict with the landlord's land management plan in theory. Clearly, if land management plans are to be strategic, and of course they should be, then it would be anticipated that landowners would engage meaningfully with all who have rights associated with the land. Amendment 20 ensures this must happen. Finally, Amendment 33 allows the Commissioner to publish guidance on how owners are to comply with the requirements mentioned in section 44B3, which effectively sets out the information that a land management plan must contain. Such guidance can give landowners more clarity or certainty, which they deserve actually, as to how the requirements are to be met. I have lodged this amendment as it complements my Amendment 30 on monitoring of land management plans, which will be considered later within Group 7. I would ask all members and Government to give consideration to all amendments in my name within this group. Thank you.
Thank you very much, Mr Doris. I now call Ariane Burgess. Finally, you get to speak to one of your amendments, Amendment 311, and any other amendments in the group. Ariane.
Thank you, Convener, and thank you for your warm welcome to the committee this morning. The Green amendments in this group seek to strengthen the provision on land management plans. Amendment 338 is the most critical. It strengthens the duty on landowners from simply preparing land management plans, and I think I'm going to go forward calling them LMPs, just so I don't have to tongue twist around land management plans a lot, to actually implement LMPs. If plans are prepared but then simply languish on the shelf, there will be no progress made in giving communities a greater say in how land is actually used. It also hinders large land holdings being managed for climate and nature, an idea that was central to the government's public consultation in 2023, and it would be well, we certainly can't have this loophole in the Act. Amendment 337 increases the time period to be covered by the LMPs from 5 years to 20 years. If, as the government intended when it consulted on the bill, LMPs are to be a key tool in delivering progress on climate and nature targets, they must take into account the fact that many actions need to be taken over longer timescales. It could be a decade before actions taken begin to produce positive effects for climate and nature. Longer LMPs mean that climate-positive actions have time to come to fruition and less likely to be chopped and changed every 5 years. Amendment 311 is consequential to this, and 313 and 314 ensure that LMPs are still reviewed every 5 years, with communities consulted on developments and revisions. And finally, Amendment 316 adds a requirement for landowners to submit a report to the Land and Communities Commissioner at the 5-year point, ensuring that there is oversight of plans being delivered over 20 years. And I just briefly comment on some other amendments. We're certainly supportive of Bob Doris' amendments 16, 17 and 20, and probably 33. Rhoda Grant, I'd be interested to understand why Rhoda Grant believes Amendment 312 is needed, and we're going to be listening carefully to Amendments 335 and 340 to understand the purpose of those. Thank you.
Thank you very much, Ariane. I now call Rhoda Grant to speak to Amendment 312 and any other amendments in the group.
Thank you, Convener. Amendment 312 would ensure land management plans comply with the format prescribed by Scottish ministers, and this ensures that the plans meet the terms of the legislation while being simple to produce in a given format. Evidence around the costs of producing land management plans varied widely. Therefore, having to hand a pro forma makes it simple to pull together. That said, large land holdings will already have plans around managing their land unless it's derelict, and they should be able to bring that together into a given format quite simply. Amendment 315 extends the review period from 5 to 10 years, taking account that land use patterns are slow to change, such as tree planting, peatland restoration and the like, can all take decades, and this allows additional time before a review has to be carried out. Where there is significant change in this during this period, the bill allows a framework for changes to be made to land management plans already, and I think 10 years strikes a reasonable balance. I believe that Tim Eagle's amendment of 20 years is possibly far too long. Yeah.
Listen carefully to Rhoda Grant there in relation to 10 years being a good period for land management plans. I wonder if the member believes that land management plans should be monitored on an ongoing basis, and how that monitoring should take place should be specified within the plan itself. Because if we reach 5 years into a land management plan and the landowner hasn't sought to work out what are they achieving the aims and objectives set out in the plan, that's an issue whether it's after 3 years, after 5 years, after 7 years or after 10 years. So would Rhoda Grant agree with me that however long land management plans last for, there must be inbuilt monitoring within that as a matter of course?
And I believe that land managers would do that. For instance, if you're planting trees, you need to know how many you've planted. You need to manage them. They make sure that they are growing properly, that the conditions are right for them. And if something goes wrong, you obviously have to take stock and go back. And the same with things like peatland restoration. And the same with growing food. You need to plan that ahead to make the soil sure the soil is in the right state to grow the crops you're looking for. So land management is not something you do and walk away. You would have to continually monitor what you're doing. Amendment 334 is reasonably self-explanatory in that there is a conflict where Scottish ministers would be very unlikely to impose regulations on themselves. And I think it would strengthen land management plans for Scottish Government who own crofting estates to be able to appoint someone in their stead to fulfil their obligations, especially when there is a conflict. Amendment 340 allows the Commissioner to decide whether one land management plan is required for multiple holdings or whether each holding should have an individual plan. While it is likely that an owner would have one plan, there are maybe situations where the land holdings are very different and different plans are in place. And this amendment works, of course, with Mercedes Villalba's amendments, where non-contiguous holdings have a cumulative effect.
Rhoda Grant, does any other member wish to speak? I would like to say a few words or a few questions, if I may. No one else? Okay, so I'll start off. First of all, I think it's quite interesting. I looked at Amendment 23 produced by Tim Eagle, which were required, stated that new management plans don't have to be produced for a year after purchase. One has to beg the question of whether the Cabinet Secretary, of course, is going to support that, based on the fact that Glen Prosen was purchased in 2022 and there still isn't a management plan for it. So I understand the need for it, but I'm not sure the government has a great record on that. As far as the management plan and lengths, I agree with Tim Eagle that 20 years is probably more reasonable because land management, especially for basic land management, takes a long period of time. And I think forest management plans take even longer than that as their timescales. So 20 years seems entirely reasonable. And the cost of production, which we heard in the evidence session of the committee, varied, but I think it was settled on that a reasonable figure for a small land management plan could be in the region to £15,000 to £20,000. If you're going to have to keep redoing that every 10 years, that is a huge burden on relatively small holdings of land. So I have concerns about that. I listened to Bob Doris's definition of accessible plans, and I actually have some sympathy with accessible plans and on a single function of how to find them. I can see that growing arms and legs. One only has to look at a publication, Who Owns Scotland, to see that the best way of defining things is by a map-based system, which would create a huge cost if there were maps for every area. I will give way to you, Mr. Doris, in a minute. If I can just finish my train of thought, is that there would be difficult. And also, I've listened to the Cabinet Secretary's view about the fact that the Cabinet Secretary didn't want land management plans to become formulaic, and nor did anyone in the committee. And therefore, if it becomes an online format, which is drawn up, gives me huge concern that it will be formulaic to fit the website that it goes on. Mr. Doris, did you want to come in?
I did, Convener. My apologies. I didn't want to interrupt your train of thought either. I'm glad you arrived at your destination. It just gives me the opportunity to highlight my Amendment 31 in Group 7, which are associated to Amendment 16 and 17, which give the Scottish Government regulation-making powers to knit all this together and to make this work in a proportional way, which I should have mentioned within Group 2. But didn't. But also just to say to the convener that there's a policy intent here, and I'll listen with interest what the Scottish Government says in relation to this. There's many ways to skin a cat, convener. The policy intent is that this must be publicly accessible, not simply available, and it shouldn't be burdensome on the person trying to find it, just as much as it should not be burdensome upon the landowner.
And I thank the member for that. And for clarity, of course, accessibility of land management plans and forest land. Scotland are probably the perfect example that you can go straight onto an area of the map and find what they're doing in a particular area and when all the felling's going to happen. Well, if you can find that, you tell me where it is, because I can't find it. So I think this may grow arms and legs and could become incredibly expensive. So I would like to know more about that before I could support it. My other slight amusement, I guess, when I looked at the amendments put forward by Ariane Burgess, that one of the amendments that the purchaser of, and correct me if I go wrong, Ariane, is one of the purchaser of a estate would have to adopt the plan of the previous owner. I think that was within your amendments. That made me smile. It would make me smile that if that was the case, of course, then at Glen Prosen, if this was the situation, the Scottish Government would be letting grouse shooting. Is that what you intend by that? It might not be that adopting the plan of the previous owner is something that you intended. Did you want to intervene, Ariane?
Thank you for bringing that up. It's not the intention, but what we're trying to do with this amendment is, going forward, if we create land management plans that are adhering to climate and nature emergency, which is what the agricultural bill, the natural environment bill, everything is pushing us towards, we're going to have plans that hopefully help us meet our 2045 climate targets and actually address the 20 by 30 commitment, which is not very far away, which is 30% of Scotland's land and sea protected by 2030. So what we're trying to do here is get plans that going forward actually don't chop and change, and we are looking at that long-term action on the ground, peatland restoration, forestry, conservation, all that kind of thing, rather than switching and changing. So that's the intention here. Convener.
I hear what you say, Ariane. I mean, my concern would be that adopting the previous plans of a previous owner might not be a rationale for, a reason for success. Again, I'll go back to an estate just south of Aviemore where it was planted in trees and all the trees have died because the trees weren't planted in a suitable location. So if that was in the management plan, you would be tying the next owner to plant more trees so they could die. I don't think that necessarily ties in. And I think that also it would adversely affect people who are wishing to buy. For example, I think we visited, and I can't remember the name of the estate south of Perthshire, where it was a sporting estate where the new owners had stopped all the sporting on it and were planting trees, creating wind farm, fencing out all the deer with an aim to create the target. If they'd been tied into producing sticking to the land management plan that was there before, none of that would have been possible. Ms Doris, did you want to come in?
Convener, I'm sure you know this already, but I want to draw attention to my Amendment 32, Group 7, which specifically looks at the transfer of land from one owner to another and appropriate transitional arrangements. So I hope I'll get your support for that when we reach Group 7, Convener.
Well, I think, Ms Doris, I'll look at that amendment when we get to it. I'm talking to Arian Burgess' amendments in this group. So I have concerns, and I guess I wanted to say finally that just to clarify, when it comes to land management plans, I believe 20 years is a reasonable figure because I think it's a long-term figure. But if the committee wasn't minded to do that, I would find it easier to support Rhoda Grant's amendment for 10 years rather than 5 years, which I think 5 years in the scheme of land management is virtually a blink of an eye. And on that note, I will end what I'm saying and hand over to the Cabinet Secretary, unless any other committee member wants to say anything. Cabinet Secretary.
Thanks very much, Convener, and really just to thank colleagues around the table for their engagement, well, more widely with the bill, but I think particularly in relation to some of the matters that we're discussing for this grouping in the process and implementation of land management plans. Just to say, first of all, I welcome Amendment 20 from Bob Doris, which looks to specifically require that regulations have to provide for landowners to ensure that they engage with tenants, crofters and small landholders with rights associated with the land on the development of and significant changes to land management plans. That was always going to be the intention of the regulation, so I'm happy for the amendment which makes that more explicit. In relation to Amendment 33 from Bob Doris and also Amendment 10 from Tim Eagle, these look for there to be additional guidance on how landowners will comply with their land management plan obligations under the regulations. So again, it was always the intention for there to be additional guidance. So I'm happy for that to be explicit on the face of the bill. But for drafting reasons, I would ask both Bob Doris and Tim Eagle not to press those amendments, and I'm happy to work with them ahead of stage 3 to bring forward amendments that are going to meet the stated aims of both of those. Both amendments take a different view on how guidance must be produced, what it should cover and who should produce it. One amendment suggests Scottish ministers, the others suggest the new Commissioner. I agree that the content that both amendments highlight should be covered in further regulations or in guidance. So I'll consider how best that could be reflected in the bill and whether that responsibility should indeed lie with ministers or with the Commissioner. Now, we've heard amendments 21 and 315 to the timescales proposed for review of land management plans, and these amendments seek to increase the intervals of reporting. The amendments from Arian Burgess also seek to introduce a new plan period of 20 years with a review and report every 5 years. And of course, I understand the rationale for that, and that it's to encourage plans to set out activity for the next 20 years. But the bill already requires plans to set out that long-term vision, and I think it's appropriate for guidance and regulations to set out more detail of what that means, including the time span that the plan should cover. The NSEC Committee in Stage 1 report noted that the 5-year reporting cycle that we've set out already, that it seeks to strike a balance between ensuring plans remain current, but also not to impose unrealistic or unhelpful obligations on landowners. So to me, that indicates that I feel that what we have set out does strike the right balance. So to that end, I would ask members not to support Amendments 21 from Tim Eagle, 315 from Rhoda Grant and Amendments 311, 313, 314, 316 and 337 from Arian Burgess. Yes.
So, Cabinet Secretary, so I understand that you're proposing that we stick at a 5-year management plan cycle.
Well, that would be for review of the plan. That's not the duration of the plan. And as I set out in my comments there, that we would look to regulation and further guidance to set out what the overall duration of the plan would look like. So that's what I feel like we've struck the right balance in terms of having that review every 5 years. OK, so Cabinet Secretary, sorry, I'm being very careful that I don't make this into a conversation, because I will disallow conversations later as convener, I'm sure. But could you clarify then your thought process on what you think the duration of a plan should be? It's fine to say that you'll come to it later. Are you thinking it should be 10 or 20 years? Well, again, it's not for me to set that out right now, because I think we would need to do more work on that and engagement across the piece, because that's where, I don't necessarily, I think what Rhoda Grant has proposed also in relation to Arian Burgess, I do feel like there's an agreement to be reached between us here, but just that I don't think fixing that into primary legislation is the way to do it. So with that, I'll proceed. In relation to amendments 390, 18, 391, 19, 392 and 396 from Tim Eagle, they look to do away with the requirement for regulations to provide for obligations to ensure that there are land management plans and engagement with communities on them altogether. Or they only require regulations to provide that landowners must ensure they engage with a restricted category of persons and only on the development of plans and not on significant changes to them. And they introduce in regulations an ability for landowners to report members of the community. I feel these amendments are against the spirit of what the bill is looking to achieve, and that's why I would ask members not to support them. I also recommend opposing Amendment 340 from Rhoda Grant. Yes?
It's just on Amendment 391, which, when I was listening carefully, it looks more to define what a community is and to actually say it's within the vicinity of where a land management plan is being formulated. Does the Cabinet Secretary not feel that, you know, if there's no definition just now, it could leave it open to, like, campaign groups, for example, just putting a view in for on a land management plan that are not actually affected because they don't actually live in the vicinity of the area that's it's being discussed?
But again, I think how would you then go on to define that? Or I think it actually becomes trickier when you try to do the opposite and you do try to put too much of a definition on that, which is why I'm asking that that wouldn't be supported. So I've set out in relation to those amendments, again, why I don't believe that we should be supporting them. And I was just turning to Amendment 340 from Rhoda Grant, supported by Mercedes Villalba, which would allow the Land and Communities Commissioner to advise a landowner where they have multiple land holdings in scope on whether a combined plan is appropriate for these holdings or if they should have separate plans. Now, I understand that this amendment is there because it ultimately supports amendments made elsewhere looking to bring in aggregate land holdings across Scotland. So this amendment I don't see as being required for the bill. Regulations will make provision for owners of single and composite holdings to ensure that there is a land management plan and that engagement with communities as well. I'd also like to note Amendment 23 from Tim Eagle and Amendment 317 from Ariane Burgess, which deal in quite different ways with the issue of a new owner of an in-scope land holding. And I appreciate the need for clarity that's been suggested around that, but I think as Bob Doris has highlighted in the debate that's taken so far today, I think that that is the amendment that he mentioned. I think it's Amendment 32 in Group 7, I think is the more suitable way to be able to deal with that. And that amendment would allow the Scottish Government to set out through regulations the detailed requirements of how landowners must comply with their obligations in relation to land management plans, including in circumstances where ownership of that land is transferred. Now, I would say that, of course, in relation to that too, future regulations could also provide the owner with a grace period of a year within which the owner would have the option to either keep most of the existing plan that was there or consult on a new one. And that's where I agree with Bob Doris that much of that detail is best placed in future regulations and developed with the benefit of consultation. I think it's appropriate the bill doesn't prescribe the level of detail of the manner in which the obligation in section 44B1 on land management plans must be complied with. And that's why we'd ask members not to support Amendments 23, 317 and to support Amendment 32 when it arrives in Group 7. Amendment 17 seeks to ensure that all land management plans are publicly available in a single portal. I appreciate and agree with the intent of that amendment. However, I just can't support it as it's drafted right now because it puts a requirement on a landowner to ensure that the public body takes action. Instead, the landowner should only be required to share the land management plan or make it available, and the requirement for publication on the portal should sit with the public body. So I'm happy to work with Bob Doris ahead of Stage 3 to ensure that we get that amendment right. In terms of Amendment 16, also brought forward by Bob Doris, that inserts the word accessible into section 44B, requiring landowners to ensure that there is a publicly available land management plan in relation to the land. Now, I'm concerned that the amendment doesn't provide sufficient detail or clarity on what exactly is to be accessible, whether that's in relation to the language that's been used in the plan, or whether it's a requirement to ensure that the plan can be easily obtained. So I appreciate I think the reasoning behind it. Again, I would ask Bob Doris not to press it, and I'm happy to work with him ahead of stage 3, again, to make sure that we get the drafting of that right. I believe that the Rhoda Grant's Amendment 312 overcomplicates the process. It introduces a requirement that land management plans must be made in a format specified by Scottish ministers. Now, we already have powers through Section 44A to set out further detail relating to land management plans, and that includes the information that they have to contain. So I don't think that the amendment is necessary, so that's why I would ask members not to support it. Amendment 335 seeks to require that Scottish ministers should appoint an independent person to complete the land management plan for crofting estates owned by Scottish ministers. I would say that so far we haven't heard evidence to suggest that this is a view that's shared by crofters on Scottish Government-owned estates, or we haven't had any concerns raised directly from the Scottish Crofting Commission or the Crofting Federation about that. We already exercise our land management functions in a transparent, accountable and also in an inclusive way too, which brings significant social, economic and environmental benefit for rural communities. And I think it's important... Oh, yes?
Some concerns in this regard, so I just wonder if the Cabinet Secretary would be willing to look at that and discuss that ahead of stage 3 to see if we can find a way that gives people comfort.
I would be happy to have that further discussion with the member about it, because, as I say, it's not a concern that's been raised with me directly, which is why I was wondering why this amendment had come forward. Because I do think that it would be important for somebody, if they're acting on behalf of Scottish ministers, that they engage in the same way that we would expect of any other large landowner, rather than a separate person who would then be expected to take on that responsibility. We engage with our tenants, we also engage with local communities when we're developing long-term proposals on crofting estates and gather information about that. So I think putting that duty on an independent person or an external party instead of the Scottish Government would amount to an information transferring process from the Scottish Government to someone else for the purposes of writing a plan, and it would also have resource implications associated with it. So in any rate, I think we would prefer, and I do think it is really important too, that we undertake our own engagement with tenants and crofting communities on the crofting estates. So that's why I would ask members not to support Amendment 335. But regardless of that, I do want to pick up that conversation with Rhoda Grant and understand more about some of the concerns that she's been hearing. And lastly, I would urge members not to support Ariane Burgess's Amendment 338, which looks to place an obligation on the owner of land to implement the land management plan. I do have concerns about this, as land management plans aren't intended to necessarily control how land is used or managed, but just to provide that greater transparency about about that and engagement on this. So I would like to offer to work with Ariane Burgess, though, ahead of stage 3, to see if we can bring forward an alternative amendment, but that would ultimately have the same aim. So it could require, for example, that a landowner should set out in a plan at review any progress that's been made on implementation of the actions that have been set out within it or within previous plans. Thank you.
Thank you, Secretary. I now move to Tim Eagle to wind up and press or withdraw Amendment 10. Tim.
Thank you, Convener. I wasn't going to make much of a closing statement other than to say that thank you to the Cabinet Secretary for her responses, and I'll take those on board. In light of what the Cabinet Secretary said about working with me towards stage 3, I won't press Amendment 10.
Tim Eagle wishes to withdraw Amendment number 10. Does anyone object to this amendment being withdrawn? No member objects. Therefore, Amendment 10 is withdrawn. Now, we are just about to go into the next phase of quite a long debate. So I'm proposing that we have a 9-minute break. So I'd ask people to be back here at 10:50. That's my military background. So back here at 10:50, I suspend the meeting. Thank you. Back to this meeting of the Net Zero Energy and Transport Committee. We now move on to the next group of amendments, and I call Amendment 11 in the name of Michael Matheson, group with amendments as shown in the groupings. I remind members that if of the preemptions and direct alternatives in this group, as are set out in the groupings, can I ask Michael Matheson to move Amendment 11 and speak to all the amendments in the group? Michael.
Thank you, Convener. This Amendment 11 sits alongside several other amendments within this particular grouping and essentially is aimed at seeking to explore some of the issues around sites of community significance. The Cabinet Secretary will recognise that the issue of land reform encompasses both urban and also the rural context, and as drafted, the bill as it stands at the present time does not cover the area of rural, only doesn't cover the area of urban Scotland and other settlement types, unless, as it stands in the bill just now, they are situated on a large land holding. Consequently, the bill, as it's shaped at the present time, doesn't provide a mechanism which would ensure that the public interest is considered in urban land management and or urban land sales. I'm aware that in the response that the Scottish Government received to the bill's consultation, some 67% of respondents in that consultation were in favour of the inclusion of urban Scotland within the bill's provisions. I'm therefore keen to explore with the Cabinet Secretary how we can try to address some of the issues, in particular the pressing issue in urban and peri-urban areas, which can at times be blighted by what is vacant or derelict land, absentee owners, corporate landowners who use the land as land banks. In drawing this together, I'm conscious of some of the complexities potentially around it, which is why these amendments are largely to probe and seek the government's view on dealing with this issue, because I recognise there is a particular challenge in identifying sites of community significance, and my amendments at Amendment 42, 121 and 139 seek to try to provide some sort of structure around how sites of community significance could be identified. But given the pressing nature of this that some of our urban communities face around such sites that I've mentioned, I would be keen to hear from the Scottish Government on how they consider this issue could be addressed more effectively than we have at the present moment, and also whether, of course, if I can just finish this point, and whether there is scope within this bill for there to be some form of provision in order to address this issue. I'm happy to give way to Mr Lumsden.
Yeah, I thank the Deputy Convener for taking the intervention, and I actually agree a lot with what he's saying about, in terms of urban Scotland, there needs to be much more done to get derelict sites out of being derelict and actually back into use. So, but as we took evidence during the last few months, we never really took evidence on urban Scotland and some of those issues because it wasn't really in the bill. It wasn't really part of the scope of the bill. So does he really think that it would be right for us to open that up now when we haven't taken any evidence, and maybe was it, in hindsight, we've all got 20/20 hindsight, a mistake that it wasn't actually part of the original bill that came forward?
No, I think it's, although we never explored it in detail, there will always be a case at stage 2 where amendments will come forward in areas which we haven't fully explored, including, for example, looking at electricity infrastructure being put in place. So, but that's not to say they shouldn't be explored, and that's why I've drafted these amendments specifically in or they have, and I should thank the Community Land Scotland for assistance with this. It's largely to try to explore this issue further, to see if there is a way in which we could seek to try to address what is a pressing issue around land banking, derelict land and absentee landlords that hold land in urban areas which communities do feel are significant and of value, that they would like to see something being done about them and action being taken. And these amendments are framed in such a way as to try to provide some form of structure around that, notwithstanding what could be some of the challenges that would be in trying to implement that. Of course.
Thank you, Michael, for giving way. My question is that under the compulsory purchase provisions, there is the ability for the government to compulsory purchase areas of land where there is a significant community interest. I just wondered if the member had involved or had discussions with the government to find out whether the government felt that was sufficient or whether, and therefore not needing this amendment to the bill, because it appears to me it's something that governments never used and councils have never used, to my knowledge, in the past.
So I think the reality is that the existing powers aren't sufficient, which is why some communities feel that there are areas of land which they believe are of sites of community significance, that they would like to see something done about them, and they would like to be in some sort of position in order to progress that, which is why in amendments 42, 121 and 139, as I mentioned, I try to provide some structure to the organisations who could initiate that process, which goes beyond that of Scottish ministers. It allows community-based organisations to be engaged in that process and to initiate that process as well. So it's to try to give a bit more scope for the local community to be the initiator in identifying these sites of community significance. But I'm conscious that, as in any amendment where you start to list things, you inevitably end up leaving things out. But I want to open this issue up because I do think it needs to be explored further, because I don't believe the existing arrangements are working effectively. Of course.
Just listening with interest, and as an urban MSP, I think that we can all think of sites that would benefit from additional provisions. I'm just wondering whether community place plans have got a role here in terms of local place plans are developed and consulting with the community at a local level with the planning authority, and if within that a community has identified areas of particular community significance that's requiring action, whether that could in theory be a trigger for additional requirements in relation to land management plans. Just thinking about this as I'm hearing more of what you say, Deputy Convener.
I think it could be, but you'll be aware of the challenges, the range of, or the number of community place plans that have been put in place in different local authority areas, which is very limited. But equally, even once a place plan has been put in place, it may be that there's an area of land that's identified by that local community which they now view as being of significance to the community. What the intention behind these amendments is to provide a mechanism which would allow that to be triggered by the local community as an area of significance. But I do, just drawing my remarks to a close, I do recognise the complexity around this and the challenge associated with this, which is why I'm keen to hear from the Scottish Government their views on the matter, how they believe the existing system could be developed further, and also in probing this issue with these amendments is whether there is scope, whether if it's not at this stage, at stage 3, to look at trying to address some of the issues around urban land reform.
Thank you, Michael. I'm going to call Bob Doris to speak to Amendment 22 and the other amendments in the group. Bob.
Thank you. I'll restrict myself to Amendment 22 only, and I shall speak briefly on it. You'll be pleased to hear. With regard to land management plans, 44A gives ministers the power to impose obligations on large land holdings by regulation, with 44D specifying the land in relation to which obligations will be imposed upon. Amendment 22 ensures that if the Scottish ministers decide to exclude certain types of land for any reason that otherwise would have that obligation placed upon it, that when laying the regulations they must publish a statement setting out the reasons for not imposing the obligations on said land. Community Land Scotland, in meeting with them, thought this was an important addition. This amendment simply puts the need for clarity and transparency on the face of the legislation. I must admit, though, that having spoken to the Cabinet Secretary ahead of lodging this amendment, I was actually reassured that the Scottish Government would provide a rationale as a matter of course without the statutory compulsion to do so. That said, I suppose this amendment looks to future-proof should other governments take a different approach, and I would ask members to consider supporting Amendment 22.
Cabinet Secretary, you're going to speak to Amendment 34 and any other amendments in the group. Cabinet Secretary.
I appreciate there are a lot of amendments in this group, so I will try to get through them as best I can. And I'll speak to the amendments in my name before turning to some of the other amendments that are in this group. Because I think this debate is really important because it goes to the heart of what I think is a fundamental policy decision in the bill. And it's one that we gave a great deal of consideration to prior to introduction, because you want to make sure that the proposals can be applied as widely as possible. And the reason community engagement obligations were to apply to to owners of large land holdings, initially as introduced over 3,000 hectares, was so that they wouldn't have, there wouldn't be that disproportionate impact on small businesses such as many farms. And I didn't want to disadvantage them relative to larger land holdings where there would then be more staff and more capacity. Now, these are new proposals. And I want to ensure, indeed, of course, in my role as Cabinet Secretary, I have a responsibility to ensure that they are proportionate and justifiable. Now, I know at stage one the committee said it saw merit in aligning the size of the thresholds operating across the bill for reasons of policy cohesion, but importantly, I think also for clarity for stakeholders. So, as I'd said in my response to those recommendations, I also saw some merit in that, both in its simplicity and how the proposals can then all work together. Amendment 38 therefore lowers the threshold in relation to land which community obligations might be imposed from 3,000 to 1,000 hectares, and that would align the thresholds across land management plans, pre-notification and transfer test provisions. So, in essence, would cover about 55% of Scotland's land. Now, as members know, the bill already gives government the flexibility to seek to alter the thresholds based on experience. So let's not forget that these are new and ambitious provisions, and I think it is right that the government should then review their operation to ensure that they are having the intended effect. So Amendments 34, 36, 40 and 50, they're largely consequential to Amendment 38. And Amendment 40 removes a separate category of land that exceeds 1,000 hectares on inhabited islands, given the threshold for all land holdings would be lowered to 1,000 hectares. Now, moving to Amendment 49, the bill as introduced requires land owned by the same person or by connected persons to share a boundary in order to be considered a holding that counts towards the thresholds. Now, during stage one, the Land Commission noted that there might be a number of titles where public infrastructure, whether that's rail or roads, may act to sever large land holdings into smaller areas, and those land holdings may then individually fall under the thresholds that we'd set out. Now, the SLC recommended that land split by a railway and other public infrastructure should be treated as a single holding. The committee similarly recommended this approach in its report, noting that it could have then been a potential loophole. So I share the committee's view, and I consider that disregarding such a split in land holding for the purposes of the threshold to be proportionate and justifiable. Now, the amendment doesn't focus on public infrastructure directly, because I think there could also be other similar situations beyond train tracks and public roads, whether that's private roads that are held by another landowner, where similar considerations would apply. So, following consideration of how wide, looking at the width of railways, road infrastructure, this amendment allows for non-contiguous areas of land to form a holding, provided that they're within 250 metres of each other. And that allows us then to, I think, address a known issue while still being in line with the evidence base that we have, that concentration of ownership can impact local communities. Yes?
During the evidence session that the committee heard, I think it was identified there were quite a few landowners with smaller holdings than 1,000 hectares, but they weren't contiguous, which is the point you've made. And the 250 metres contiguous distance, or sorry, within 250 metres, actually is quite arbitrary. Would the Cabinet Secretary consider at stage 3 amending that to include that if the holdings shared the same machinery, management and labour, that they would be counted as contiguous? It's what the Scottish Government has done before when it has come to agricultural subsidies to identify whether there are two separate holdings rather than one holding, or sorry, two holdings working together. I wonder if you'd consider that, Cabinet Secretary.
Again, I would have to fully understand that and see what the implications of that might be, but I'm more than happy to have that conversation with the convener between stages 2 and 3, but I would still ask that my amendments would be supported by members in the meantime. Now, moving to the final amendments in this group, 45, 46 and 48, they concern how composite holdings are defined in the bill. Now, they're technical amendments to really strengthen the definition of composite holding to ensure that multiple holdings that are owned by connected persons form together to comprise composite holdings in the same way in which holdings owned by the same person form a single holding. These amendments will also support the introduction of non-contiguous holdings, which I've just spoken about in relation to Amendment 49, and I therefore recommend that the committee support the amendments in my name. Turning to... Yes?
And then there, Convener. Would that address the, we heard evidence at committee stage where, land holdings, or maybe I'm thinking of a unit trust, for example, that the ownership is split up into small little packets, even though they're being managed as one. Would this amendments cover that?
Well, if you're talking in relation to aggregate holdings, so say if it's related to holdings that are across Scotland that potentially fall under the thresholds, then they wouldn't be caught by the measures. Essentially, that's because we need to make sure we've got the evidence base for that and to address the impact of the concentration of land ownership here. So the amendments that I'm bringing forward don't cover aggregate holdings as they would be across Scotland.
Can I come back in?
Yes.
I'm talking about, we heard from Gresham House, for example, where there was sites managed as one, but there was multiple owners within that one site. Would what you're bringing forward address that situation?
Well, the definitions that we have for connected persons are what's set out in the bill already. Again, so I'm more than happy to have a discussion with the member ahead of stage 3 if there are particular issues in relation to the amendments that I've brought forward here, if he feels that they're not addressing it. But again, and I'm not too sure if we're talking at cross purposes here in terms of what we're trying to set out. But again, my amendments don't cover the aggregate holdings, which I don't know if that's the point that the member is trying to bring forward. Now, just a way to turn to Michael Matheson's amendments, 11, 35, 42 and 106. And I think, as Michael Matheson outlined, the purpose of the amendments is to extend the land to which community engagement obligations may be imposed to include sites of community significance. Now, I'm keen to ensure the bill is as simple and clear to understand as possible, but as I've also set out today, the measures that we introduce need to be proportionate and justifiable. Now, the bill focuses, following recommendations of the Scottish Land Commission, on addressing issues with concentration of land ownership in rural areas, so that's why the provisions apply to those larger land holdings. If we were to look to introduce sites of community significance, that would significantly complicate the provisions that we have set out in the bill. It would invent a whole new designation process that means that land anywhere in Scotland could be subject to provisions in the bill that were intended only for large land holdings. Yes?
Land of community significance is widely recognised as a definition, and one of the things that's really missing from this bill is urban land reform. I think that Michael Matheson's amendments are proportionate and give us that opportunity for people in urban areas and indeed rural areas where land is of significance to them to do something about bad management of that land.
I mean, I would have to check, but as far as I'm aware, I don't think there's a legal definition of what that would mean. I think we would be inserting a legal definition of something that would have wide-reaching ramifications beyond what we've set out in the bill. And I'm just a way to come on to a few other points and issues that I have in relation to that. But I do think there is a wider point that's been raised about measures that are being taken in the urban environment, which I think it's important to remember that this isn't what we're looking at in this bill was intended to deal with a specific problem that had been identified by the Scottish Land Commission, and that was about dealing with the issue of concentration of land ownership in rural Scotland in particular. But that's not to say that there isn't any work going on otherwise to address some of those issues in the urban environment. I think it might have been Monica Lennon who raised this with me in particular during stage 1 consideration of the bill. So So I'm just away to come on to talk about the community right to buy powers that we have, the review of them that's been ongoing. There's also significant work that's been taking place in relation to compulsory purchase orders. There's work ongoing in relation to compulsory sales orders too. So I think all of these different mechanisms will help deal with some of the issues that we see in the urban environment, which I don't think we can seek to address in this bill and in this legislative vehicle alone. Now, I understand that different stakeholders have voiced support for the concept of land of community significance, but they've done that in quite different ways. I think some have sought to expand the scope of the bill with it, while others have sought to limit it, requiring communities to undertake more work before the provisions in the bill could apply. Now, the process of assigning sites to be of community significance would be complex, and the enforcement and monitoring then of any registration could have significant costs for both the Scottish Government, who would have to establish a way of registering those sites, and local authorities who may be required to be involved too. Now, there hasn't been any impact assessment of how many more sites could be brought into scope, what the cost of that could be for landowners, as well as the cost for the public sector. Now, the benefits of sites of community significance are also unclear. The application of lotting and the transfer test to these sites is also unclear. There is already an existing process through which urban and rural communities can register a community interest in land under Part 2 community right to buy processes. An additional process, I think, could then add significant cost and complexity for both the landholder and the public purse, with unclear and limited benefit. Now, we know in rural areas there is a need to add an existing route to the community right to buy process, but that's why we've introduced the pre-notification measures in the bill. But we don't believe that this is proportionate when there are no issues of concentrated ownership. And I think, in fact, if we were to expand the provisions of the bill to apply beyond the target areas of large land holdings, we could then risk taking the bill away from the evidence base on which we brought forward those proposals. And I think there are also issues with legislating in this space in particular when we haven't been able to consider the findings of the community right to buy review, which is still underway, and that's due to report by the end of this year. And I appreciate the concerns that were raised by the committee in relation to that review. But I think if legislative changes are required as a result of that review, that we would then be happy to bring forward the right legislative vehicle to try and address those. So while I appreciate the approach that Michael Matheson has taken here, I believe that this would take the bill measures away from what they were intended to do and beyond what they were the issues that they were designed to address. So I would ask him not to press these amendments. Turning to Amendment 22 and what Bob Doris is proposing through this, that Scottish ministers publish a statement when exempting any land which would otherwise be subject to future regulations requiring landowners to have a land management plan. Again, as Bob Doris has outlined in the conversations that we've had, this is something that I would just expect the government to do as a matter of course anyway. But so while I'm always slightly nervous of adding requirements to the bill, which I don't believe are necessary, I'm happy to support the amendment, though I may look to revisit it at stage 3 if there are any unintended consequences found or if there are any drafting issues identified as part of that. Tim Eagle's linked amendments 398, 399, 402, 403 and 406 seek to disapply the community engagement obligations in certain circumstances, including if land is used mainly for agricultural purposes or if the owner hasn't yet previously engaged with a community body within the last 5 years. And I appreciate that Rachel Hamilton's amendments bring in a similar amendment to disapply the obligations if the land is transferred to a new entrant in farming or agriculture business. Now, I am mindful that the obligations and thresholds should be designed to avoid disproportionate duties on small-scale landholdings or smaller farms, and that's, again, why I'm not proposing to lower the threshold below 1,000 hectares, where only the largest 1.4% of Scotland's farms are expected to be in scope. We will, of course, also make all efforts to ensure that community engagement obligations are as straightforward as possible and align with other plans and requirements where possible to minimise duplication. However, I don't believe right now it's right to disapply those obligations to such a broad class of land types and landowners as these amendments would suggest, and that's why I would recommend that these amendments aren't supported. To Tim Eagle's other amendments, 37, 41 and 44, they would remove the bill's definition of what constitutes a composite holding for community engagement obligations and instead, via Amendment 405, leave these definitions to future guidance prepared and published by the Scottish Land Commission. I appreciate that there is often quite a lot of discussion here in Parliament about what should be on the face of the bill and what should be considered to be left to regulations and guidance. But I think in this case, I do think it's right that Parliament can consider what constitutes composite holdings on the face of the bill, and these, however, can of course, be changed by any future regulations. So I would ask that these amendments aren't supported. In relation to Amendment 39, that would raise the threshold in relation to the land which community obligations may be imposed from 3,000 to 5,000 hectares. Of course, that would dramatically reduce the ambition of the bill, I think particularly when there has been such widespread support for land management plans and the community engagement obligations, and as the committee will have seen when they took evidence on that too. And Amendment 401 would increase the percentage of land which forms an island under the current islands criterion to 33% from 25%. Now, as I've already outlined, I would propose lowering the threshold to 1,000 hectares here, and that would then remove the islands criterion. And I believe that that's a sensible compromise and would therefore recommend that these amendments are opposed. Tim Eagle's remaining amendments, 104, 105 and 110, would remove ministerial powers to modify Chapter 2 by regulations and instead add more restricted powers to modify the chapter. And Amendment 110 would stipulate that future regulations could not reduce the number of hectares in 44D, and the land in relation to which obligations may be imposed. And then when we look to Mercedes Viaba's Amendment 109, it's almost the complete opposite, I think, of what Tim Eagle is trying to do, as it restricts the power to modify Chapter 2 by stipulating that future regulations could not increase the thresholds for land management plans and community engagement obligations. I think both approaches would substantially restrict Parliament's future flexibility here, and I think while I probably would lean more towards supporting the intent behind Mercedes Viaba's amendment than Tim Eagle's. I know it was worth a try. As a parliamentarian, I am mindful of constraining the actions of future parliaments here, so that's why I wouldn't be supporting these amendments. Yes, happy to.
It sounds that you're saying that you support the intention behind it, and I gather from the bill that there is a particular direction of travel being set towards diversifying ownership, and therefore it would make sense to restrict, to prevent any further increases so that we don't go back on ourselves. So is there a way to bring forward an amendment to secure that direction of travel, which I think we're agreed on, ahead of stage 3?
Well, I think, again, as I've outlined, we're probably not too far in thinking, but I think what we have to, and I think being responsible in this role, we really have to, these are new measures that we're introducing. I think it's only right that we monitor the effectiveness of those and look at any potential impacts from that. And I think I am conscious that, again, I don't want to tie a future Parliament's hands in relation to this, which is why I'm proposing not supporting the amendment. I mean, of course, I'm happy to have further conversations with Mercedes Vialba after stage 2 and as we look towards stage 3. But again, I'm not minded to support them at this stage. Ariane Burgess's Amendments 3 and 4 would lower the threshold for land which community obligations may be imposed to 500 hectares. But I do believe this is too low for the reasons I've outlined earlier. I want to ensure that the proposals are justified in relation to the policy aims and do not have a disproportionate impact on smaller landholdings. And this amendment would impose costs on a much more significant set of landowners. And as I've just outlined in my response to Mercedes Vialba there, the provisions in the bill are new, and I think it's important that the government is then able to review how they're being implemented and monitor that, and we then have the ability to seek to adjust the thresholds in the future if that's required. So that's why I would oppose these amendments. In relation to... Oh, sorry, yes.
So does this mean that you're not ruling out a future reduction in the threshold to 500 hectares?
I mean, again, I'm not ruling anything in or out at this stage because we haven't yet introduced a threshold of 1,000 hectares. And I think how that is implemented, it's really important that we review and monitor that and see how it is operating, but once it has been introduced. Now, turning to Mercedes Vialba's Amendments 43 and 47, they remove the requirements for single land holdings to be a contiguous area of land and for composite holdings to be contiguous with each other. So this would mean that if a landowner owns more than 1,000 hectares in total across all their Scottish land holdings, then the provisions in the bill should apply. Now, I appreciate that there are members and stakeholders more broadly who would want to see those land holdings brought into scope where there is a larger distance between holdings, and I do have sympathy with that, but the evidence base which underpins the bill bill and the measures we've introduced focuses on that concentration of ownership and its impact on local communities, and we don't have the evidence base to justify measures tackling aggregate holdings across Scotland, as I outlined in my earlier response to Douglas Lumsden. And Mark Ruskell's amendments 49, I'll just finish the point that I've started. Now, Mark Ruskell's amendments 49A and 49B would include non-contiguous areas of land, provided they're within 10 miles of each other. Now, of course, this figure is much larger than the 250 metres that I've suggested based on the recommendations of both the NZEC Committee and the Land Commission, but I am mindful that our evidence is focused on nearby land holdings, and broadly, the greater the distance that we have to allow non-contiguous land holdings to be treated as contiguous, I think the further that the intervention then moves away from the original evidence base, as I've outlined already today. So, but I would like to think that there could be some middle ground in relation to this. I know that there are some examples that Mark Ruskell may well touch on today and that he's referenced before, that in particular issues there that he would look to address. So I would like to work with Mark Ruskell in relation to those amendments going forward. And sorry, Mercedes Villalba, I'll come back to your intervention point.
Thank you. Thank you for taking the intervention. It was just on the point you made about not having the evidence base to address aggregate land holdings. And I wondered if you could say a little bit more about that, because it's the case, is it not, that the national concentration of land ownership was recognised as an issue by the Scottish Government, and it formed part of the consultation for this bill, but now it's not being included, and that seems to go against research and findings from the Scottish Land Commission. So I'm interested, it caught my attention hearing you say that there isn't an evidence base for it. It's not clear to me what that's being based on.
Well, it is based on the evidence that had been provided by the Scottish Land Commission, and the issue that we're ultimately trying to tackle here is the concentration of land ownership and the impacts that that can have on local communities, because it means there isn't the diversity and land supply available, and those are the issues that we're directly trying to address. Now, somebody could, and that's the thing, it's not to say that I'm not sympathetic with exactly the issues that I think Mercedes Villalba is trying to address here. But again, we don't have the evidence base for that, or to show that if somebody owns land in other parts of Scotland, it's the impact of, you would have to, and it falls below the threshold, you don't have the evidence base to show the impact on the local community near that area of land, but it may not be relevant anyway if it falls below that threshold.
So does that mean that the government's position has changed and that you no longer recognise national concentration of land ownership to be a problem for Scotland?
Our position hasn't changed throughout the duration and the discussions that we've had on this bill. The key point that we are trying to address, and all the measures that we've been introduced, are based on the Scottish Land Commission recommendations in terms of how we can try to address the issues that are associated with the concentration of land ownership in Scotland and the impact that that has on local communities. But it's those large land holdings within a specific area that we can see some of those issues arise, and that is the point that we're trying to address with the measures in the bill, but our position hasn't changed.
I'm just seeking clarity on that position, on national concentration of land ownership.
Mercedes, sorry, if I just say, it's always very difficult at stage 2 is to make sure there's an open debate, but it doesn't need to be a conversation across the table. So I'm gently pointing you to ask a question, followed up maybe with another question through me, and then you can address the issues when you get to speak in your section. Otherwise, I fear we could be here till Christmas, which may be a good thing, but maybe not. So one more question then, and then...
just on that specific point of national concentration of land ownership, does the Scottish Government recognise it as a problem?
Well, concentration of land ownership we do recognise as a problem, and again the policy aim and the ultimate objective of what we're trying to address here is the effect of the concentration of land ownership in an area, and also on the impact that has on local communities and on the supply of land to local communities, which is why we have the measures that we've set out in the bill and why we're directly trying to address those problems. Now, finally, again, I just want to... Yes?
So just picking up on the national concentration of land ownership that Mercedes Villalba has been raising, if this is not the legislative vehicle to do this, what assurances can the Cabinet Secretary give the Parliament that we will be addressing the national concentration of land ownership and this issue of aggregate landholders, because that does have an effect on communities. So I recognise that this bill is about having a direct land that is directly affecting a community of place, but the national concentration of land ownership is having an effect, and we need to find a way to address that.
Well, there are a number of different measures. I would say that, in particular in relation to that, how we are addressing this are through the measures that we've introduced in the bill. For, I think, looking at management of our land more widely, making that more transparent, but also through the transfer test and the proposals that we have through lotting, because ultimately that is about trying to diversify land ownership in Scotland, why we have those prohibitions in place that they can't just all go to one owner, because we're trying to do that, diversify the land supply and diversify the land ownership in Scotland. So we are addressing it, and that means, is this bill, and would it ever have been able to address the significant issues that we have in relation to the management and ownership of land in Scotland? No, it can't do that. But we have to make sure that the measures we introduce, we have the basis for that, the evidential basis to introduce those measures, so that, of course, they withstand any challenge that could come forward and could come our way. I've already mentioned a number of other pieces of work that are ongoing at the moment that can potentially happen in could potentially help in the urban environment. We've got the community right to buy review as well. And again, this bill is one step right now. It, of course, cannot fix all the problems, but I do believe that we are introducing new measures, new policies in here, which hopefully will have a significant impact on that and will be another step on the land reform journey that we talk about. And finally, Convener, you'll be pleased to hear that I just want to briefly comment on Douglas Lumsden's amendments 343 and 344. Now, as I said when I was commenting on similar amendments from Douglas Lumsden in Group 1, of course, this is a matter of interest within my constituency. I want to make it clear before committee today that I'm here in my capacity as a Minister of the Scottish Government, and the position that I'm presenting reflects the collective view of Scottish Government and concerns a matter of law and policy for which I have ministerial responsibility. And separately, and in line with the Scottish Ministerial Code, I've made my views and those of my constituents known to the responsible minister in the appropriate way. However, the issue under discussion today is distinct from that constituency interest, and my contributions today should therefore be understood as reflecting the Government's position and not a personal or constituency-specific stance. But I say that, on the whole, in relation to the amendments brought forward by Douglas Lumsden, I'm not too sure how they would fit with the current drafting of the bill, and that's why I would recommend that members oppose these amendments at this stage. Thank you, Convener.
Thank you, Secretary. And I'm now going to call Tim Gould to speak to Amendment 398 and the other amendments in the group. Tim.
Well, thank you very much. I fear I might be slightly longer than Boris, but slightly quicker than the Cabinet Secretary, so we'll try our very best. I appreciate the Cabinet Secretary's thoughts on my amendments 398 and 402. I think my genuine concern there was around, I think I see a significant difference between a multiple portfolioed estate and an agricultural holding, which might be just an upland sheep farm, and the consequence of potentially a land management plan on those. And I just felt that actually the burden of the plan would be too much for those purely in the agricultural sector. My amendments 399 and 403 seek to address concerns relating to the thresholds of land. Thresholds seem to me to be a little bit arbitrary and not based on evidence of particular outcomes depending on a particular scale. So for community engagement, there should be additional criteria which are markers for what success looks like, effectively a threshold plus test. So this amendment adds in additional criteria that there is not already a disclosure statement or management plan, and the owner has not already engaged with a community body in the vicinity of the land in relation to the management of the land within the last 5 years. My Amendment 37 is consequential to Amendment 41. Amendment 41 and 44, the bill currently as drafted says that obligations can be imposed on land which is either a single holding or a composite holding. As drafted, a composite holding is one which consists of any number of single holdings. I do not believe it rational to include a composite holding. We are concerned that this could include holdings which are not located anywhere near each other and have widely different land management requirements. Therefore, Amendment 41 deletes composite holding, and Amendment 44 deletes all reference to composite holdings in this section. NFUS gave the example that if a landowner is selling, transferring an area of land in the Highlands, it has no relevance to another landholding that may be in East Lothian. It does not impact the same community and therefore should not be included. In my Stage 1 speech on the bill, I asked why size has been chosen as the key measure for who is impacted by the bill and why not value. There is a huge difference in my mind between 3,000 hectares of moorland and 3,000 hectares of prime agricultural land. Whilst I'm not sure I understand fully the size rationale, my Amendment 39 nonetheless seeks to remedy this by increasing the hectare threshold from 3,000 to 5,000 hectares. SLE have disputed, Scottish Lands and Estates, have disputed using size of an estate as an indicator of adverse impacts on Scotland. Scottish Lands and Estates have said there appears to be no evidence that there is a detrimental impact on Scotland due to the scale of land holdings. The Scottish Land Commission's own evidence points to the issue being potentially one of concentrated land ownership in specific areas rather than scale itself. In addition, NFU Scotland believe the bill could have significant implications for Scottish agriculture. NFUS expressed concern over the delivery of this legislation. They said the proposals around land market regulation have the potential to severely compromise farming. Economies of scale have meant that farms have had to get bigger to survive. I am seriously alarmed and absolutely opposed to both the Cabinet Secretary's amendments and Arian Burgess's amendments that seek to reduce the threshold figure. This is the very heart of the bill, and to lower the thresholds at stage 2 was with, as far as I am aware, no prior consultation with stakeholders such as SLE and NFU Scotland is bad lawmaking. Dropping the figure down to below 1,000 will catch too many farms and land holdings that, while large in acreage, are not large in income. One farm that will be caught by the new threshold is that of Tardo's farm, a sheep farm in the Muirkirk uplands in East Ayrshire. Cora Cooper, who runs the farm, recently briefed us all on the challenges that their farm is facing. They are first-generation farmers with 2,023 hectares. They have a peatland restoration plan to restore 800 hectares of damaged peatlands. Cora told me that they are already facing increased costs from Labour's national insurance rise, they have a business loan to pay off, and now the SNP government are planning to impose a £15,000 administrative burden for a land management plan every 5 years on the farm. They feel they are doing everything right. Why would we want to penalise them? Absolutely.
For giving way, and I think actually, populating this debate, explaining examples is a really good way to proceed on it. I'm just thinking, though, I mean, the farm that you described sounds like a great farm. Sounds like they've already got a plan for what they want to do in the future. They've got peatland restoration. They've got a really clear idea about where they're going. Surely it comes down to the format of the land management plan, the guidance that's associated with that, because if it was a case of consulting on the land management plan or any access arrangements and what their future, farm management plan is, that it sounds to me like, because that's a professionally run farm with a farming family at the heart of it, that all that information is there, and that it could be, a land management plan could be a fairly simple thing to pull together, and perhaps a really exciting conversation with the local community about how the community can support and feed into what Cora and a farmer are attempting to do.
I think that's actually a good point. And actually, I don't know if you've spoken to Cora yourself. She's very keen to actually speak to people. My understanding is she's already very actively involved in the whole unit is very actively involved in the local community. And I guess the point that they were trying to make to us is on two parts. One, because they are doing everything that they feel the government is already asking them to do, why are they being drawn into this bill? And secondly, I don't think they feel they have the detail yet of what the land management plan will be. If it is literally just a combination of bringing together the plans they already have, then you're right, that might not be overly burdensome, but I don't think they're clear on that, and that was what they were expressing to us as they got ahead. But as I hope, I suppose, over the next few weeks that we get to learn that moving forward. Absolutely.
First of all, just to make clear in relation to that, I think that's why consultation and engagement on what's to be included around that is so hugely important, and that would be a vital part of the process. So just to recognise that. I think I also just want to draw on some of the examples that you had raised about the costs associated with that. Now, some of the figures that we'd set out in the financial memorandum, I mean, £15,000 has been, I think, mentioned a couple of times today, but that was for a very complex example, and I think quite an extreme example of some of the costs that would be expected. But also, it's not as if that would be a recurring cost every 5 years as well. But again, a lot of this, we need to consult with people. We want to make sure that we get the level of detail right, which is why we've set out the process, and I hope that you would recognise that within the amendments that we're looking at and the discussions that we've had in the bill today.
And actually, I do think I do take that on board. I guess I'm using that 15,000 because my understanding was that it was brought out during the stage 1 debate. But I also think I'm trying to get across that point that there are some people, particularly upland farmers, that are particularly concerned about what the implications of this legislation will be to their agricultural units. And I appreciate the points the Cabinet Secretary made during her remarks. I'll turn now to my amendment 401. As drafted, the land size threshold for an island is inhabited land. An island is inhabited land which forms a single or composite holding that exceeds 1,000 hectares and constitutes more than 25% of the land forming the island. We believe that the land size threshold is too small and should be increased to 33%. My amendment 405 addresses concerns we have over the use of the term composite. This amendment seeks to require the Commission to prepare and publish guidance for the purposes of creating clarity on what constitutes a composite holding, and in doing so, they are required to consult appropriate persons. The bill, as originally drafted, allows ministers to modify Section 1 of the bill by regulations. Their powers to modify include changing what land the ability to impose regulation on relates to, and also the persons who can report a breach of obligations. We believe that this is too wide-ranging a power, and so Amendment 104 proposes to remove these parts. My Amendment 105 also seeks to avoid ministers being able to lower the land size threshold in the future. My final amendment in this group is Amendment 1110. Currently, as drafted, the bill allows ministers by regulations to change the land which obligations are imposed on under Section 1 of the bill. Whilst our first choice would be to remove this power, as set out in our Amendment 104, we would seek this amendment if Amendment 104 is not successful to ensure that the land size threshold set out in parts of this section cannot be reduced in the future. Thank you, Convener.
Thank you, Tim. Now going to ask Douglas Lumsden to move Rachel Hamilton's Amendment 400 and speak to other amendments in the group.
Yes, thank you, Convener. Unfortunately, Rachel Hamilton had to leave for another engagement. On these ones, if we're serious about food security, about rural prosperity and about the future of Scotland's farming, then we must be serious about supporting the next generation of farmers. And that's what these two amendments, 400 and 404, aim to do. We're trying to remove another hurdle for new entrants into the industry, and the amendment gives new entrants the breathing space that they need to get their businesses off the ground without the immediate burden of preparing complex land management plans. And for many, the cost and complexity of these plans could be a barrier too far. Young people in the communities deserve a government that matches their ambition, and we shouldn't be burdening them with red tape from day one. And I was listening very carefully what the Cabinet Secretary said about the amount of farms that would actually be caught by this regulation or this legislation if it was 1,000 hectares, which I think was only about 1.3%, I think the Cabinet Secretary said. But of course, this threshold could be brought down by regulation. So what we're trying to have on the face of the bill is protection for new entrants into farming. So if the threshold was brought down in the future, then they would be given the breathing space of 10 years before they have to produce that plan. Of course.
Can I thank him for giving way? I mean, I've met quite a few sort of young farmers, new entrants into farming over the years, and what strikes me is that they've got a lot of energy, they've got a huge amount of vision, they've got a lot of passion for what they want to do, and surely, a land management plan at the heart of this should be a way of articulating that vision and actually having that conversation with the surrounding community. I feel that, like most people, setting off in farming for the first time, maybe carrying on from a farming family, from a relative as well. But every time you get that generational shift, there are new ideas that come in, new exciting ideas about the way that they want to take the business forward. And surely that, in the essence of it, should be the conversation in a land management plan. It shouldn't be a threat or red tape or regulation. It should be about getting the community behind you and actually having that conversation about the future and what's needed.
No, and I agree, and a lot of people coming into the industry will have that energy and vision. But, it's like setting up any new business, whether it's agriculture or something else. We need to try and encourage that as much as possible, and to give them the space. And that's what this amendment is trying to do. It's to try and give that a little bit more time before they have to go through the expense of a land management plan and get their thoughts together on how the land would be used as well. And that's the basis behind these amendments. Convener, did you want to speak for my amendments as well?
No,
right.
you will come to yours in a moment. There are other members before you.
I will leave the
Mr.
comments
Lumsden.
on 400 and 404 at that then, Convener.
Thank you. Therefore, I'm going to call Ariane Burgess to speak to Amendment 3 and any other amendments in the group. Ariane.
Thanks, Convener. Amendments 3 and 4, alongside those in later groups, seek to lower the threshold to 500 hectares, and this brings significantly more land into scope of this legislation, furthering Scotland's progress to land reform. I recognise and hear the Cabinet Secretary talking about the fact that that could happen at a future date, and that there's a keenness on the Scottish Government's part to monitor the situation with 1,000 hectares, but the Scottish Land Commission's research suggests that 93% of land sales are for areas greater than 500 hectares, so this would be a proportionate change to the threshold. Yeah.
I thank the member for giving way. We heard, having 1,000 hectares, it doesn't really bring in huge amounts of farmland. I think it was 1.3%. That the Cabinet Secretary set out. So if it was brought down to 500 hectares, what percentage of farmland would then be brought into having to create land management plans?
So, as I just said, the Scottish Land Commission's research suggests that 93% of land sales are for areas greater than 500 hectares, so this is a proportionate change to the threshold. It also increases the number of land holdings that we require to produce land management plans, and that would give more communities a voice, and I think that's what we're saying is at the heart of this, a voice in the management of their local land. I also want to acknowledge my gratitude to Mercedes Villalba and her work on thresholds. She really brought that strongly into the public discourse over the years, and I'm grateful that she's going to be supporting these amendments. I do note that the government's amendments reduce the thresholds to 1,000 hectares, and I understand, again, that the Cabinet Secretary has brought in amendments to harmonise the thresholds 3,000 and 1,000 for simplicity's sake, and I think that that does make sense to have a clarity around one threshold for everything, so appreciate that. Just coming back to a conversation we had earlier in this grouping around the national concentration of land ownership, I think what I believe, but I won't put words into her mouth, but I believe Mercedes Villalba are trying to get at is that there is an issue of land that is under these thresholds owned by the same landowner but scattered all over Scotland, and it's something that we absolutely need to address and bring in into scope. Not necessarily understand for this land reform bill, but I would like to hear assurances from the Scottish Government about what we can do, and I understand CSO, compulsory sales orders, compulsory purchase orders, community right to buy review and all of that. But I think as a collective, we need to be really addressing this and finding a way forward, which is not necessarily about more communities taking land, but how do we actually address that issue of this aggregate holding and the power that that has over Scotland, really, in a way. Yes.
Thank you. I'm grateful to Ariane Burgess. Just in relation to the point from Douglas Lumsden, who raised legitimate concern about ensuring the long-term viability of agriculture in Scotland, I wondered if Ariane Burgess would like to join me in encouraging Douglas Lumsden to have a look at the research and the proposal for my own proposed land reform bill, which found that just 3.6% of agricultural land holdings are above the 500 hectare threshold.
I would be delighted to join Mercedes Villalba in suggesting that to Douglas Lumsden. And I also think that there's an interesting aspect that we have in play, which is that some of us worked on the Agricultural and Rural Communities Act, which requires a whole farm plan. So as my colleague Mark Ruskell pointed out, there's that enthusiasm, that energy in farmers, but there is also a requirement for whole farm plans to be brought forward. So that work is already there, that data is already there, that information is already there. What land management plans are asking is that that information then gets shared with neighbouring communities so that they can have a say and be involved and feel that they have a connection to what's going on land around them. And at that, convener, I'll conclude.
Thank you very much, Ariane. Mercedes Vialba, can I ask you to speak to Amendment 43 and any other amendments in the group? Mercedes.
Thank you, Convener. Very pleased to speak to Amendment 43 and my other amendments in the group. And again, I would like to thank Community Land Scotland and the Scottish Parliament legislation team for their support in drafting them. The bill, as introduced, makes it clear that provisions for land management plans, lotting limits and transfer tests apply to single, composite or contiguous landholdings. Now, as it stands, this means that non-contiguous landholdings over the threshold will not be subject to the effects of the bill. This means a single owner of multiple holdings that amount to many times the size of the large landholding threshold would be unaffected by the effects of this bill. Yet the stated purpose of the bill is to address the national concentration of land ownership across Scotland. And the Scottish Land Commission find that aggregate holdings and complex ownership structures do pose challenges for transparency and applying the provisions in the bill. Therefore, my amendments 43 and 47 remove the limitation that holdings must be contiguous, thus removing loopholes around non-contiguous landholdings and ensuring aggregated landholdings over the threshold are included in the scope of the bill. If agreed to, these amendments would ensure that aggregate landholdings are included within land management plan requirements, prior notification requirements, public interest test requirements, and would remove the loophole of landholdings being severed by infrastructure. This will remove the requirement for landholdings to border each other and ensure that large landowners of multiple holdings across the country are in the scope of the bill. Amendments 43 and 47, taken with Amendments 122 and 125 in Group 10, and Amendments 140 and 145 in Group 12, therefore remove loopholes on contiguous landholdings and include aggregated landholdings. A later amendment, 182, in the name of Bob Doris, Group 16, introduces a duty on Scottish ministers to regularly review these thresholds. It's vital that we future-proof the legislation to sustain the direction of travel towards greater diversification of ownership. Therefore, my Amendment 109 amends inserted Section 44M 2016 Act to specify that, quote, the regulations must not increase the number of hectares that the land must exceed in order for the obligations/prohibitions to be imposed on the land. Amendment 109, taken together with 133 in Group 10, and 171 in Group 12 ensures that thresholds cannot be revised upwards. Labour supports Amendments 3 and 4 in the name of Ariane Burgess, which seek to lower the threshold to 500 hectares, something I've long campaigned for and which we welcome the Greens' support for. Thank you.
Thank you very much. I'm now going to call Douglas Lumsden to speak to his Amendment 343. You don't have to repeat everything you said when you were speaking on behalf of Rachel Hamilton either, however tempting it may be, Mr Lumsden.
I won't repeat myself, Convener. Just on the my own amendments, 343 especially, it's good to hear that Ariane Burgess and Mercedes Vialba recognise that some landowners owning land scattered across all of Scotland, and I would suggest that some of these landowners that have land scattered across Scotland is actually electricity infrastructure companies. So I'm sure they'll have no problem in supporting that amendment there. Because all I'm saying in here is those landowners that have land scattered across Scotland with electricity infrastructure on board should be having to produce a land management plan that would obviously go through the same community process as everyone else. We're going to speak to another couple of amendments. Deputy Convener raised about urban Scotland, and I completely agree with the points he's raising there. I think we've all got areas in our constituencies where there's absentee landlords and derelict sites, whether that's in the city centres or even in brownfield sites, and I think it would be good to explore that further, and be good also to see if anything can come forward in stage 3 of the bill to address some of those concerns. I only want to speak about the threshold being potentially reduced from 1,000 down to 500. So we heard that that would increase in terms of land used for farming up from 1.3% of what land is. That would bring it up to, I think it was 3.6% that Mercedes Vialba had raised. But that doesn't give the full story. You know, how many farms would that then take into account? How many farms would then have to produce land management plans? And we don't really have that figure, and the impact that would have. And you know, I guess farmland is changing as well. I would imagine some farms may be getting bigger as the cruel Labour family farm tax kicks in, as we see areas of farmland being bought and sold. So there may be a bigger impact to farmers. So I think the last thing they would need on top of that cruel farm tax is to have more red tape and more bureaucracy built in and cost. So I'll leave it there, Convener.
And Mr Lumsden, I kind of let you get that word in twice. I won't let you get it in again. I mean, you can refer to the farm tax in relation to this bill. So I just, committees are in this Parliament. I'm very proud of the fact that committees are apolitical, and so you can put your views about it, but not in that way, please. So, Mark Ruskell, can I ask you to speak to Amendment 49A and other amendments in the group?
Yeah, thanks very much, Convener. So just to rewind a bit, 49 from the Cabinet Secretary aims to put in a definition of a contiguous holding, and I think it addresses the evidence that we took at stage one, where you might have a holding, but it's got a railway line running through the middle of it, and that's not then seen as contiguous. So I appreciate what the Cabinet Secretary is trying to do here. What I'm doing in amending that amendment is replacing the suggestion of 250 metres as a definition of contiguous with another figure, with a 10-mile figure. And I think it comes back to what the CabSec said around what people kind of understand as being nearby land within an area. I think it's important that land holdings with the same owner that have boundaries within let's say 10 miles of each other should be treated as contiguous holdings. I think most people who live in communities would see those as being broadly contiguous, broadly being nearby land which they feel that they have a stake in and they want to be part of a conversation with the landowner on. And so this, switch from 250 metres to 10 miles is really to address cases where multiple land holdings are being bought up in communities by one owner, but are effectively being managed as a single entity. And of course, this committee took evidence from a number of witnesses about the example of Taymouth Castle Estate and Glen Lyon. It was raised at the town hall meeting that we were at, Convener, in Aberfeldy. And I think it's fair to say that within that example, where you have a single owner, a Discovery Land Company that owns both Glen Lyon and Taymouth and a number of other assets within the community, that their proposals have been less than transparent. There's been a feeling in communities that whether they're broadly against or broadly supportive of what DLC are attempting to do, that people don't really have a full understanding about what the final vision is and the final plan will be for both of those estates, which are being managed together effectively, for the years ahead. And I think that lack of transparency, that lack of a long-term plan, is causing a lot of division within communities. I see it within Kenmore, I see it in Aberfeldy. I know that the First Minister, in his role as constituency MSP, has been asking DLC for that long-term management plan for the area, so that people at least know, whether they're broadly supportive or not, kind of what is coming forward. Instead, all we really have at the moment is the planning system, and the planning system is throwing up very, very small minor applications for buildings to be built on either estates or change of use for particular assets, and it doesn't really provide that full picture about how the community may change for better or worse going forward. So I really think that point about nearby land, as the CabSec put it, is really important, and that need for transparency. I appreciate that bringing the threshold down from 3,000 to 1,000 hectares might have some benefit there. In this case, it would include Glen Lyon within the purview of a land management plan, but it wouldn't then include Taymouth Castle. It wouldn't include all the other assets that DLC are operating and land that they're operating within the area. So it still leaves that question about what the overall vision is and the community's involvement within that. Just briefly, I mean, at Michael Masson's point about sites of community significance, I think that is important, and I think it's perhaps that we've a missed opportunity that this bill didn't deal with the urban, aspect of it, although hear what the Cabinet Secretary says, there are more reforms to come, particularly around community right to buy. But again, this is another issue within that area of Loch Tay, in that DLC have bought up hotels, they bought up tourist accommodation, caravan parks, hotels, shops, the lot. And again, people don't really know how that's being managed. So I would hope that, at least if this version of this amendment could go through and that a land management plan would apply to all those assets, that it would also allow some clarity over those sites of community significance as well. Ultimately, I think this bill will be judged by communities about whether it actually improves the conversation locally, whether it brings transparency. I think right now, certainly my constituents, folk that we met at the town hall meeting, would call that into question. They don't really see this changing that conversation, changing that transparency. So I really hope that we can agree something at stage 3, regardless of whether it's 10 miles or another definition, that really provides much more of a common sense understanding of what is nearby land and the kind of conversations that need to be had on the back of the transparency that land management plan would bring. So I appreciate the Cabinet Secretary's offer to discuss this further and to look at that definition again ahead of stage 3, and I think that will be certainly of interest to people on both sides of this debate around Perthshire. Thank you.
Thanks very much, Mark Ruskell. Does any other member want to say anything? Because I started a trend, I am just going to say a few things, if I may, and I'll try and keep them as short as possible. I'm mindful that in Scotland we've looked at land reform in 2003 and 2016, and that one thing that really has avoided land reform is urban areas, which the Deputy Convener brought up. And I actually have some sympathy with his sites of community interest, and I would like to see that developed more. Sadly, as it stands at the moment, within the proposed amendments, I'm unable to support it, but I do hope that the Cabinet Secretary and perhaps a wider group can discuss how this may be taken forward, because I think it is a missed opportunity, especially when urban areas probably there will be more people affected by sites of community interest than out with in the rural areas. So I think that is something that would be worthy of further consideration. As far as the issue on ownership is concerned, I'm not sure the Cabinet Secretary, in my mind, satisfied me that the ownership issues would be resolved, in the sense that if it's a group of owners and they are marginally different, that is not the same owner, as I think was highlighted. I'm not sure what the solution is, but maybe the Cabinet Secretary will look at that a bit more. The other issue I would say is on the contiguous ness of holdings. 250 metres and 10 miles are wildly different, and maybe wildly different in the area of which we're talking about, whether it's in the Highlands, in a remote area, or in a rural area, or a semi-rural area. And my concern is that we haven't got this right. But it can't be just as broad as anywhere in Scotland, in my mind, either. For example, that there are many people within the Highlands who have upland farming interests, where they have their sheep during the summer and may have winter grazing elsewhere, maybe in the south of Scotland where the weather is more hospitable in the winter. So I'm not sure what the solution is, and I'd be grateful to work with the Cabinet Secretary if the offer was available, to look at ways of doing that, to try and make it that it was along the lines of I'd suggested, dare I repeat myself, that if it's shared ownership, shared labour and shared machinery and shared livestock, it might be something that could enable this to be drawn up together as a management plan, because then there is a significant amount of sharing rather than two different holdings. And I'll probably leave my comments on that. The Cabinet Secretary, of course, hasn't jumped to the occasion by saying she would be happy to discuss it with me. But
would you like me to come in?
yeah, I'm very happy, Cabinet Secretary, having prompted you.
I did say in my earlier comments, I'm more than happy to have a conversation about that. But I mean, again, I think because of some of the issues that have been raised, I would need to seek advice on that to gauge whether that is something that would be possible or not.
Okay, and I thank the Cabinet Secretary for that. And on that basis, I'll leave any further comments and push to the Michael Matheson to wind up and press or withdraw Amendment 11. Michael.
Thank you, Convener. I've listened very carefully to the comments that have been made by committee members and also from the Cabinet Secretary. And I'm conscious of a couple of arguments being deployed by the Scottish Government around the need to keep the bill simple and clear, which I agree with in terms of land reform, but also that it's a bill which is specific to try to address an issue which the SLC sought to identify as well through their own report. My only slight pushback in some of that is that the bill as it's drafted doesn't actually adhere to all of the areas that the SLC identified and didn't accept all of their recommendations. And equally, the scope of a bill is within the hands of the Scottish Government when it's been introduced and how far they wish it to go. I do think we have to be mindful that we are, rightly through this bill, empowering communities within rural Scotland in a way that communities within some of urban Scotland will not have the same powers over significant pieces of land within their local area. And if there is a requirement for a land management plan for significant rural land, then why shouldn't there also be for significant urban land as well? So I think there is an issue there. I recognise that this bill is probably not the place to address this issue at this stage, but I certainly would encourage the Scottish Government to explore further, if not at stage 3, but in future legislation, how we can address what I think is a growing disparity between the rights of communities within rural Scotland and the rights of communities within urban Scotland. And on that note, I will not move Amendment 11.
Thank you, Michael. Michael Matheson wishes to withdraw Amendment 11. Does anyone object to this amendment being withdrawn? No one objects. Therefore, the amendment is withdrawn. We're now going to move on to the next group, and I'm going to call Amendment 389 in the name of Tim Eagle, group with Amendments 397 and 341. Tim Eagle to move Amendment 389 and speak to the other amendments in the group. Tim.
Many thanks, Convener. I won't take very long over this one. Move Amendment 389 in my name. My Amendment 389 and 397 seek to delete all of the inserted Section 44C regulations to include obligations to consider community requests to lease land. I believe that the policy intention in this section is unclear, and I would welcome more details from the Cabinet Secretary of what would be within these regulations. What does give consideration, for example, mean in practice? I feel this adds an unqualified responsibility onto the landowner and therefore should be deleted. With regard to Rhoda Grant's MSP's Amendment 341, we would prefer to delete Section 44C, so I am not able to support this amendment at this time.
Thank you, Tim. I'm now going to call Mercedes Fialba to speak to Rhoda Grant's Amendment 341 and any other amendments in the group. Mercedes.
Thank you, Convener. Amendment 341 would add a community request to consider to constitute land as crofts for the purpose of croft creation under Section 44C. Currently, the provision allows for community bodies to request the lease of land. Adding the explicit option for communities to request croft creation can empower local communities to produce food for local consumption through sustainable and regenerative agricultural practices and provide croft housing for those growing said food.
Thank you very much. Does any other member wish to speak? It's a bit unfair, this, Mercedes, because it is Rhoda Grant's amendment, but my concern regarding this amendment is that the amendment seeks to move crofting out with the crofting counties, which has huge implications. And I would ask the member, if the member was here, what the implications of this would be to the costing of crofting and the running of crofting in Scotland, and whether that's been taken into account. I suspect not, because it would have increased the crofting house scheme and also the cost of the crofting commission, which causes me huge concern. Maybe the Cabinet Secretary, who's about to come up next, can allude to those problems, unless you particularly want to, Mercedes. No, I think we'll let the Cabinet Secretary do that. So, Cabinet Secretary, I'll move to you.
I'm more than happy to come in, Convener. We didn't come up against similar issues with that amendment because it does specify crofting counties. So, again, that wouldn't be a concern that we had in relation to that amendment. I think I just want to come back quickly and I think touch on the amendments from Tim Eagle. Ultimately, we included section 44C within the bill as part of the overall aim to strengthen and improve transparency and engagement between landowners and local communities. And communities, and of course that includes tenants and crofters, should already be engaging with landowners through the land management plan and the community engagement process, but we specifically included 44C so that regulations must require specific consideration by landowners of community requests to lease land. And that's in recognition of the fact that access to assets, whether that's land or buildings, can of course be vital for community development and sustainability. And the option to lease may be just as valuable as the rights set out under the right to buy legislation. So that's why I'm content that it's appropriate for future regulations to set out the detail of how landowners should give reasonable consideration to requests and how community bodies should make these requests. And I think it is important that when we're developing those requirements that we do that with the benefit of consultation. And I think turning to Amendment 341, again, we didn't encounter the same issues as what you found, Convener, but we overall welcome the intention of Rhoda Grant's amendment, which seeks to do something very similar to what we're already trying to do through 44C, bringing forward that requirement for regulations to provide landowners to consider reasonable requests from communities to constitute land as crofting land. I do think that there is merit in considering the amendment further. I think in particular to ensure that reasonable requests by crofting community bodies are considered by landowners. But we have some issues with the drafting of the amendment at the moment because it doesn't quite achieve that in the way that I think the member would. So I'll just finish my sentence, Convener. And so that's why I would like to offer to work with Rhoda Grant. If she doesn't want to press the amendment right now, I'm more than happy to work with her on that. I have concluded my comments, Convener, but happy to take a point from you.
It was just a brief question that if you were considering granting further land into crofting, which bit of crofting legislation, which bit of the 3 bits of crofting legislation would you bring it under? Because one of the things that needs to be done to make crofting work is a reform of crofting legislation. Are you not in danger by increasing crofting per se, further muddying the water as far as the legislation is concerned?
I'm not concerned about that at the moment, and the member will no doubt be aware of the crofting bill, which has just recently come forward. But I do think that, again, there's not under any obligation to, this is about considering those requests from those crofting community bodies as well. And again, while the drafting isn't quite right, I support what the amendment is trying to achieve.
Thank you, Cabinet Secretary. I'm going to call Tim Eagle to wind up and press or withdraw Amendment 389.
I have nothing to add, Convener, but I will press Amendment 389.
Right, just to clarify, in order to try and speed things up, I'm going to change the way I said I was going to do the voting. So the priority of the committee is to ensure that everyone watching this session is aware of how people have voted in each situation. We have a member online, Kevin Stewart. So when Kevin Stewart votes, I will say how he is voting so people can see, and hopefully that will speed it up rather than doing a roll call. So the question is that Amendment 389 be agreed. Are we all agreed? We're not agreed. There will be a division. Those people in favour of Amendment 389, please raise their hands. Those people against Amendment 389, please raise their hand. Kevin Stewart has voted against the amendment. And those who wish to abstain. There are 2 votes for, there are 5 votes against, there are no abstentions, so therefore the amendment is not agreed. I call Amendment 12 in the name of the Cabinet Secretary group with amendments shown in the grouping. Cabinet Secretary to move Amendment 12 and please speak to other amendments in the group.
Thank you, Convener. As I've said in previous evidence sessions with both the Delegate Powers Committee as well as this committee, I think it's really important for the Scottish Parliament to have the appropriate scrutiny powers for each regulation that stems from the bill. So I have carefully considered the committee's recommendations, and that's why I've brought forward a number of amendments in response to many of those. Some of these recommendations are to include statutory duties to consult on the face of the bill. So I think, as I set out in various responses, I would already expect the Government to undertake the appropriate consultation, but I am happy to add statutory duties to consult across a number of powers on the face of the bill, and Amendments 15, 108, 132, 162, 165 and 170 do that. Amendments 12 and 13 make a technical change to the power in section 44A, which requires ministers to consult such persons as they consider appropriate before laying regulations rather than before making regulations. And Amendment 175 inserted section 67(4) V4 provides a power to Scottish ministers to make further provision about compensation by regulations, including how claims for compensation are to be made and how the amount payable is to be determined. Now, this is currently a negative power, but the Delegated Powers Committee recommended that the affirmative procedure was more appropriate. Now, while I had considered the negative power in this instance to be equivalent to similar powers in previous land reform legislation, I'm happy to accept their recommendation on this, and so 175 would ensure that the regulation-making power is instead subject to the affirmative procedure. And Amendment 165 also means that there's a statutory duty to consult on any of those regulations. I think moving on to Tim Eagle's amendments, I hope that I can also go some way to meeting the intention of what he's trying to achieve with the group here too. I think firstly, Amendment 417 would place a pre-laying procedure on regulations stemming from the regulations to modify Chapter 2 to be made under inserted section 44M. So I appreciate a pre-laying procedure was recommended by both the Delegated Powers Committee and this committee. Now, of course, again, I want to ensure that Parliament has the appropriate scrutiny powers. The Parliament would have to agree to any regulations made here, as they already use the affirmative power, and there will be that statutory duty to consult. Now, the bill already specifies the land in relation to which those obligations may be imposed by regulations in section 44A and in the list of persons in section 44E2 on the face of the bill. So any future regulations are really to modify what's there rather than to introduce new powers, where it is more common to see that pre-laying procedure. So that's why I would therefore recommend that Amendment 417 is opposed. Now, Amendment 458 would attach a similar procedure to the power in section 67V4 of Land Reform Scotland Act 2003 to make further provision about compensation. The DPLR committee recommended that this power be subject to the affirmative procedure, which my Amendment 175 would do, and it also recommended a statutory requirement to consult, which again my Amendment 165 does. So it didn't recommend a pre-laying procedure, and that's why I would also ask that Amendment 458 isn't supported. Amendment 161 is very similar to my Amendment 162. It adds that statutory duty to consult in relation to the power in section 67S, but it includes a requirement to prepare and publish a report on the consultation. But I think what I would say in response to that is that it is standard practice to publish the details of any consultation. So again, that amendment just seems unnecessary. In addition, the amendment suffers from drafting flaws because the consultation requirement for regulations subject to the affirmative procedure should be before laying rather than before making. So I would ask that this amendment is not supported. Amendment 165A would amend my Amendment 165 to place that statutory duty to consult in relation to the power in section 67V, and it would require ministers to specifically consult a person who is an accredited valuer of land. Now, given that section 67V concerns compensation, seeking of advice from accredited persons or appropriate bodies would, I think, be an expected part of the development of those regulations, and that, I just think that this amendment in that case isn't necessary, and it would also be unusual to require consultation with an individual rather than a category of persons or a professional body. So those are the reasons reasons why I would ask that this amendment isn't supported. But, however, I am keen to work with Tim Eagle on the remainder of the amendments in this group, 217, 219 and 220, because I think, similar to others here, these amendments would expressly require that Scottish ministers consult with people that they consider appropriate prior to making regulations under certain paragraphs of the schedule. So I'm open to including a consultation requirement on the face of the bill in relation to these powers to reflect the intention of these amendments. So if Tim Eagle is happy not to press those amendments, I'd be content to work with him ahead of stage 3. And with that, I move Amendment 12 in my name, Convener.
Thank you very much. Cabinet Secretary, I now call on Tim Eagle to speak to Amendment 417 and any other amendments in the group.
Thank you, Convener. And as just expressed with the Cabinet Secretary, a lot of these actually relate to sort of parliamentary oversight, and I appreciate her comments on 217, 219 and 220. My Amendment 17 was about improving parliamentary oversight on the regulations triggered by this framework bill. This amendment requires all draft regulations made under this part of the bill to be laid in front of Parliament, and the views of relevant committees needed to be sought on those matters. My Amendment 161 regarded newly inserted section 67S, which allows for ministers to offer to buy land following a review of the lotting decision. They must, however, be satisfied that the fact the land has not been transferred since the lotting decision is because the land is less commercially attractive than it would have been had the lotting decision not prevented it from being transferred along with other land. There are a number of conditions already in the bill relating to how this would proceed. Subsection 6 allows for ministers by regulation to make further provisions about buying land. Amendment 161 would mean that before making regulations under subsection 6, ministers would be required to consult relevant persons and prepare and publish a report following that consultation. My Amendment 165A amends the Cabinet Secretary's Amendment 165 and simply requires that during the consultation, one of the consultees is a person who is an accredited valuer of land. My Amendment 458 again seeks to improve scrutiny of this framework bill. It applies to the inserted section 67V, which allows for ministers to make regulations relating to compensation. The amendment requires any draft regulations to be laid before Parliament and the relevant committees to be consulted. My Amendment 220 relates to when ministers can make regulations to modify the basis on which a valuer can assess compensation payable and the consideration to be given to certain matters by the valuer in doing so under Chapter 1. This amendment ensures that before making the regulations, ministers must consult persons considered by them appropriate. 219 and 220 are similar, except considering different regulation-making powers. It is essential that ministers consult those with knowledge and understanding before making changes, in my mind. This will allow for the avoidance of unintended consequences and that the views or interests of all those involved are taken into account. Thank you, Convener.
Thank you very much. Tim, any other member wish to speak? Well, I'm not going to. So, Cabinet Secretary, would you like to wind up?
I've got nothing more to add, Convener. I just move my Amendment 12.
Thank you. So, the question is that Amendment 12 be agreed. Are we all agreed? Agreed. We are agreed. I call Amendment 13 in the name of the Cabinet Secretary, already debated with Amendment 12. Cabinet Secretary to move formally.
Formally moved, Convener.
The question is then that Amendment 13 be agreed. Are we all agreed? We are agreed. Sorry, Mr. Eagle, you're not quite on the committee yet.
Sorry, I'm just enthusiastic, Convener. That's the...
Okay. Right, now, we're at a difficult point here in the script because we are about to go into another section which will require debate, and then there will be a series of votes which will take us well beyond the time that I've allowed for the committee this morning. So my proposal is to hold it there. I would have to say at this stage on record that we haven't got as far as we'd hoped. And we will have to work out as a committee, which is part of our work programme, what we're going to do as far as continuing the stage 2 of this bill. So that's something that we've got to look forward to, and Cabinet Secretary, we will be in contact with you once we've discussed our work programme. So I'm going to close that part of the meeting, and we're now going to move into private. Thank you.